My lord, may I have kind leave to mention item number 59. Well, it is for extension of interim order. Well, it will be taken up serially. It may not reach. My lord, if your lordship kindly fix at 2, I can give notice to the other side, my lord, and come back at 2.
Okay. Item number
59.
extension of interim order.
My lord.
So you want to serve upon other side.
I have already given them notice, but if your lordship fix it at 2, I shall give another notice. my lord.
Today too?
Today 2.
No. Tomorrow.
Tomorrow.
Tomorrow under the same heading. Not today.
Tomorrow at 2 p.m.
Not 2 p.m. Under the same heading. It will appear tomorrow.
At the
Please
top.
serve.
At the top.
Not at the top. It is the only matter extension of interim order.
Yes, my lord. If it is not reached, my lord, in that
If it is not reached, I will take up the matter tomorrow. Okay, at that at any time. You serve notice. Next, call the matter.
The compelling circumstances may not have received certain active emergency that will not. The petitioner participated in the selection process for FPS license, but the operative will not. Favoring the private respondent would not, as on date, do not have the document, the photographs will not. As on date, the private respondent do not have will not the godown will not. There is a shop room will not, which exists will not, upon the will not, here you I wrote will not. And with neglecting all these prior to rejection of his candidature, we are submitted a comprehensive representation, stated all the facts before the authority, but we not, this is a clear case of nepotism coverage, we not, the authority will not, day before yesterday, we not rejected the candidature of the petitioner, we not, and issued the will not license in favor of the private respondent. If such thing is not established, we not, it will create will not some, not, so we not, this matter is required to be heard.
What is it? Have you filed it?
No, we don't have not had great leave, Lord.
Leave for what? Today is not be done today. It cannot be done today. Tomorrow. Tomorrow. Yes.
May I be permitted to seek leave to file one urgent writ petition, Lordship, dispense with Rule 26, Lordship, that similar matter Lordship has already held, that regarding the point 11.5 of the Control Order 2024, Lordship, that the clause regarding the 45 age bar, Lordship. Lordship, I heard several matter, Lordship, leave may be granted to file and come back on Thursday, Lordship, upon servicing,
No,
Lordship.
some matter
As
are
Lordship,
yet to be heard by the learned Advocate General.
whatever, let the matter be appeared under the same
When
heading,
the
Lordship.
matter is appearing,
Lordship, I seek leave to file and come back after servicing, Lordship. Unless leave is granted, Lordship, we are on Tuesday, Lordship.
no,
It
I
will
want to
not
know, do you know when the date was fixed?
that I don't know, Lordship. I will.
There are batch of writ petitions which was fixed for hearing.
But Lordship, there is an interim order. I am taking for the interim order, Lordship.
Yes, interim order is there.
Yes, I am
Learned
also praying for.
Advocate General is moving this matter.
Yes, your Lordship.
These
In my matter, Lordship,
These matters, how many matters?
there are 5 matters, Lordship.
These
Similarly,
matters can be tagged with that matter.
yes, and I need the same protection, Lordship. That is my.
There is no such protection like that. Some matters are moved by the learned Advocate
I
General.
have annexed the order, Lordship, as your Lordship
I
passed.
know the order.
Yes, your Lordship. Your Lordship has
Why
passed the
you
order.
are not taking the?
Yes, your Lordship. Now, what is the urgency is that, Lordship?
I know the urgency. The
Yes.
matter is that Advocate General is arguing on this matter against the interim order.
Yes, your Lordship.
I want to know the date so that the matters can be fixed on that date. The single order can be passed on that matters. Learned Advocate General already started the argument against the interim order.
Lordship, then I can suggest only one thing, Lordship, leave may be granted and let the matter be listed under the heading of to be mentioned on Thursday. In the meantime, I will
Thursday, I don't have the determination like
that's
that.
why, Lordship, I am seeking leave, Lordship.
How can it be done only?
Otherwise, Lordship, that
days?
summer holiday will be started, Lordship. My matter will be infructuous.
That's why I want to know when what is the date?
Yes, Lordship.
Very well, very well. Okay, leave is granted.
Grateful to you.
I will arrange that.
My lord,
Leave granted.
On Thursday, Lordship.
Not Thursday. Only leave granted.
Leave granted to file, and when returnable date, Lordship, I have to put the returnable date. On Thursday, Lordship, because
Thursday, group 1 is there, you know. So how can it be?
It will come under the heading of
Either
to be
it
mentioned, Lordship.
appear on the same day when the learned Advocate General is fixed to hear this matter, either or after vacation.
But Lordship,
Only one day is there, you know.
I know, Lordship. That's
I
why I'm
cannot
seeking leave.
Separately pass the order.
If Lordship will grant me that liberty to come under the heading of to be mentioned and let the matter placed before the similar heading.
হবে আজি?
Yes, your lordship may fix on 22nd.
Okay,
Lordship,
that's
22nd.
why I want to know.
Get full
So you
lordship.
do not know the matter, so
Lordship.
22 at 2 p.m.
My
On that date, 4 matters are fixed, the
Yes,
similar
your lordship.
matters.
Yes, get full lordship.
My lord, may I be permitted to mention item number 137 of today's list, my lord. It is a vacancy matter under 2013 control order. If your lordship could kindly fix it up any day within the Friday.
Tomorrow mention matters.
Mention. Grateful. Your lordship.
Item number
137 of today's list, my lord.
137. Tomorrow mention matters,
Great.
137.
May I have your lordship's leave to mention 9 matters, my lord, for extension of interim order, my lord. These are from the circuit bench at Jalpaiguri, my lord. It was mentioned twice before the circuit bench, my lord, but the file is lying in the principal bench, my lord. That's
Why
why,
these files are maintaining in the principal bench? These
But
are
all-
the benches.
my lord, we had mentioned twice before the circuit bench at Jalpaiguri, but the honorable judge presiding there has said that in such short time it will not be possible to bring back the files from the principal bench to to the circuit bench, my lord. And the order is due to expire today itself, my lord. Lordship kindly grants extension, my lord.
Thursday 3:30.
Lordship, I
Thursday 3:30. শুনুন এগুলো সব জলপাইগুড়ি সার্কিট বেঞ্চে পাঠায় আগে এক্সটেনশন হয়েছে ফাইল এখানে আছে ফাইল সব এখানে ফাইল যায় Thursday 3:30. Yes,
Lordship, I mentioned this matter on last Wednesday. Your Lordship directed that this matter, because this is a 2013 control order matter, Lordship, this particular vacancy already a writ petitions filed, Lordship, the interim order granted for not affecting the Lordship the notification, vacancy notification. Now, Lordship, without violating the same, Lordship, the LOI has been issued to the present private respondent of the present writ petition. Lords, I mentioned this matter, your Lordship directed to list this matter under the heading, to be under the heading mention matters, top of the list. But Lordship, today, Lordship, matter is running item number 55. So, Lordship, I am praying for some upgradation in the list, Lordship, because so that
today's list
tomorrow-
item number 55.
In this matter, I am appearing on behalf of the private respondent. There is no such urgency, your lordship. Last occasion, my senior, Mr.
problem is,
Bhutacharya-
Lordship, here is the this is
problem,
my
because
Lordship,
my client is
predicament,
running
my
the-
matter,
No, no.
how they will
No,
be
so it is appearing under the mention matter. I will take up these matters today.
Yes.
55 Lordship, this is difficult, Lordship.
Only some in this week, I shall not take up any hearing matters. I will take up only mention matters and the motion matters.
Let me matter be disposed on merit. I have no problem.
No, this matter will be taken up today.
Now, Lordship,
Yes.
if the
If not taken up today, tomorrow I will take up this matter.
As your lordship.
Lordship, may I leave to mention, Lordship, on contempt application for inclusion in the list. Lordship, earlier I have mentioned this matter, but it is not appearing in the list.
Inclusion in the list.
Lordship, contempt application.
Why not appearing?
Lordship, I don't know, but Mr.
Record is
Gupta-
not there, I think. Papers are not there. Mention
May
question.
I have your lordship's leave, my lord, to mention a matter. In this matter, my lord, in the earlier occasion, lordship has passed direction on the private respondent and the state respondent to file their affidavit of opposition in respect of my writ petition, my lord. But as of now, we have received no affidavit of opposition, my lord, and this matter is an open and shut case, my lord. The private respondent has been granted license, but he is an existing member of the Gram Panchayat, my lord. Kindly fixes it tomorrow. I will not take more than 5 minutes, my lord, to do this matter.
Tomorrow.
Yes, my lord.
How?
In the mentioned matters, my lord,
No.
I will not take.
Let be listed first. Not tomorrow. It will appear after vacation. Nini?
Okay. Oh, my lord, I am appearing for item number 10, my lord. My lord, it is only, there are some typographical errors, my lord, in this. My lord, the error is in, my lord, the 4th line of the first paragraph. My lord, it is to be order number 6, dated December 21. It has come correctly in the 2nd paragraph. But in the first
No,
paragraph,
I have
it
not
has
called the
come
matter.
as,
I have not called the matter. Let me
oh,
call the
my
matter.
lord, I heard 10. My lord, I'm sorry, my lord, I heard it was 10. My lord, I apologize.
Call the matter. Yes.
My lord, item number 10 has been called, my lord?
Yes.
Yes, my lord, yes. My lord, this is for correction, my lord. My lord, My lord, if your lordship sees the order, my lord, dated 14th May 2024, my lord, in the fourth line, it is written as order number 6 dated December 12, 2023. My lord, it should be December 21, my lord.
December 2021,
21.
not
21,
23.
23. Not
Okay.
12, my lord, not 12. It has come reverse. Instead of 21, it has come as 12.
Huh?
And my lord, in the names, my lord, in the second, which is not Mrs. Pujon Chatterjee, it is Mr. Pujon Chatterjee and Mr. Shutosham Bhattacharya, my
Okay,
juniors.
okay.
This is, my lord, all that I'm praying.
So order date would be December 21,
Yes, my lord. Yes.
not 12.
Not
on
12.
first paragraph, there is a mistake.
A mistake.
Now,
A typographical error, my lord.
The learned councils, salutations of learned councils appearing on behalf of the petitioners should be correctly read as Mr. Pujon Chatterjee and Mr. Shutosham Bhattacharya instead of Mrs. MRS. Inverted comma. In the fourth line of this matter appeared for correction in order dated 14th of May 2025. Next para. In first page, first paragraph, in the fourth line, the date should be read as 21 instead of 12. 21 ta inverted comma 12 ta inverted. Remaining portion. Next.
I'm grateful, my lord.
Even my lord, I am for the petitioner. My lord, the date of the order in the order sheet, it has 20 instead of 2025, it has been recorded as 2020.
This matter appears for correction. In the last order, the date has been wrongly mentioned as 7/5/2025. It should be read as 7/5/2025. 24 ছিল ওটা 24 ইন্টার কমা দিলাম দুটো নেক্সট মানে এটা কারেকশন করা দরকার কেন কারেকশন জন্য এসছে এখানে অর্ডারে কোনো কারেকশন আছে কি আছে 22/4 হবে 22/5 হয়ে গেছে
Lordship, I'm appearing for the
Lordship, I am
petitioner, your
appearing
lordship.
for the Indian
This
Oil
matter
Corporation.
appears for correction.
Yes, your
The
lordship.
last
The date
order in the last order, the date has been wrongly mentioned as 22/5/2025. It should be correctly read as 22/4/2025.
My lord, one more indulgence. My lord, last occasion they filed a supplementary affidavit. My lord, let them serve a copy of supplementary affidavit to us. My lord, they don't serve a notice to us, so that's why, my lord, we don't appear on the last occasion, my lord.
Lordship, it was only containing the instructions for not the
Kindly serve
client
this
did
copy,
not
my
want
lord. We have to
press.
serve our client also, my lord.
It was only the written instructions from the client, your lordship.
However, you serve a supplementary copy. You have placed the supplementary copy.
Very well,
in the
your
record.
lordship.
You serve the copy.
Grateful, your
Not
lord.
necessary to direction.
Grateful.
Next.
At 13 and 14, I am appearing on behalf of the petitioner. All documents, all matters are clear. You have to kindly take up first ballot item 14.
Lordship, at the outset, may I file my affidavit in opposition by the
Yes.
state respondents against the supplementary affidavit filed by the petitioner?
They have to serve
I have served the copy.
Lordship, kindly take up my
Dada,
item
এটা
14.
দিয়ে দিন।
Same. All documents are also same.
Dada,
This is in respect of item number 30.
yes. Let 28001.
Yes.
Lordship, kindly take up 14. Same item.
Item number 14.
I am in
Same,
13.
Same,
ठीक
same,
है.
same item.
Which in item?
I am
Actually,
in
this one was appearing.
we are in 13.
Both of are in 13.
Yes.
So who is in 14?
14.
Same. All issues, everything is same. That was appearing in the top.
Suman Gupta is there.
That was appearing in the prop, and I have been briefed on that matter.
Okay, okay.
If-
Kindly take up my writ petition.
If Lordship, we need to be acquainted with the facts and figures since he will be pleading in 14. Let 13 be taken first. যদি সেম আছে তাহলে কি আছে? তাহলে 14 is difficult.
Kindly,
I know your difficulty is there. Mr. Sengupta is there, so
Yes.
you are hesitating to do this matter.
petitioner
Mr.
before Lordship.
Sengupta, Samudra Datta and Sanatan Panja.
This
Let
matter
me
was-
see, let me see what is the
My
matter.
lord, my lord. The petitioner is a partnership firm
Yes,
and granted MR distributorship license in respect of area Malad Arambagh subdivision in the district of Hooghly.
yes,
But in the year 2015, due to natural calamity and devastating flood and waterlogging, the Panchayat Samiti of Sabhapati of Arambagh Panchayat Samiti
Ready?
requested my client to distribute 30 metric ton of rice to the flood affected areas through the Gram Panchayat. So, Lordship, kindly turn to page 20 of my writ petition.
Page 20.
আপনার
No, আমার তো different.
হবে তুই এক পেজটা বলে দে না তোরটা থেকে page 20.
yes,
But this is the instruction upon me by the Panchayat Samiti Sabhapati on 2nd of August 2015 addressing to my client Shaktipada Kundu. পঞ্চায়েত সমিতি জলমগ্ন এলাকার জন্য 30 মেট্রিক টন চাল সরবরাহ। আপনাকে অবগত করা যাইতেছে যে বর্তমান প্রাকৃতিক বিপর্যয় মোকাবিলা করার জন্য আরামবাগ পঞ্চায়েত সমিতির জলমগ্ন এলাকায় 30 মেট্রিক টন চালের প্রয়োজন। যেহেতু এই পরিমাণ চাল আরামবাগ পঞ্চায়েত সমিতি সরবরাহ করার জন্য বিশেষভাবে অনুরোধ জানানো হচ্ছে। মানে দিস ইজ এ লেটার on 2nd of August 2015. Kindly turn the page 22. Now this, as per this instruction, after verbal instruction of the subdivisional controller, I distributed 30 metric ton of rice by acknowledgement, taking acknowledgement from the concerned Gram Panchayats, which will appear from page 22. All the Gram Panchayats acknowledge, recording therein how many bags they are getting. Kindly see left hand side seal 40 bags. Then my lord 50 bags right hand side, other Gram Panchayat. Then my lord 30 bags. All the Gram Panchayat have received the rice, and individual acknowledgement is also there, which will start from page 23. 23, 24, 25. These are the all individual acceptance. 26 also. Then your lordship kindly see at page 27. A show cause notice has been issued. On 1st of October 2019, the allegation is there. If you lordship kindly turn to allegation number 5. Assessment of stock position could not possible at the time of inspection at books of account was not up to date and failed to show all godown space. Now, due to the shortage, the rice which I have been distributed as per instruction of the Panchayat Samiti, that I could not be given by the Food and Supplies Department, and accordingly in the stock register there is a shortage. Now, your lordship kindly come to page 31. On the basis of that complaint, a fine has been imposed upon me, and I have deposited the money. Page 31, my lord, 7,97,437.
yes,
Then my lord, another proceedings has been initiated. Kindly come to page 32. Again, 9 lakhs rupees. All for those shortage of rice, which I have distributed to the Gram Panchayats as per instruction of the Panchayat Samiti Sabhapati and verbal instruction of the subdivisional controller. Kindly turn to page 32. All this money I have deposited, 7 lakhs and odd, and also 9 lakhs. Then your lordship kindly turn to page, my lord, 35. I have started writing letter to delivery 36 also. That 30 metric ton rice, kindly turn to page 36, 30 metric ton rice which I have distributed, that has not been relinquished to me, replacement to me. So please deliver 30 metric ton of rice. Now, Your Lordship, kindly come to page 37. These are all addressed to the district controller along with the acknowledgement of the concerned Gram Panchayats, which will be appear from page 36, bottom left-hand side. Enclosure, Arambagh Panchayat Samiti order. Then kindly turn to page 37. This is very important. Now, this is a letter issued by the Subdivisional Controller Food and Supplies Arambagh addressing to the District Controller Food and Supplies Hooghly on 13th May 2020. Kindly see the subject, page 37. Request for replacement of 30 metric ton of rice to Messrs. Shaktipada Kundu, MR Distributor, Notun Bazar, Arambagh, Hooghly. This is to inform you that Messrs. Shaktipada Kundu, MR Distributor, Notun Bazar, Arambagh supplied 30 metric ton of rice to the Arambagh Panchayat Samiti in the year 2000 to 2015 as per required for feeding the food and rain affected people who were severely waterlogged in the area under Arambagh Panchayat Samiti. As per the letter issued from the end of the Arambagh Panchayat Samiti with request to the concerned distributor treating its emergency arising out of the so-and-so arising out of so-and-so situation of natural calamity in the letter number so-and-so dated so-and-so, copy of the letter of the Panchayat Samiti has been enclosed, and then, my lord, and also as per verbal instruction from the end of the disaster situation may be overcome. From this end, have you lordship, from the instruction of from this end, so that the disaster situation may easily be overcome. This 30 metric ton of rice received by almost all the Gram Panchayat Pradhans under Arambagh Panchayat Samiti as per individual from the signature against so-and-so, against the individual signature, against receipt of the stock of the same letter of Panchayat Samiti on so-and-so, which is enclosed herewith. So, acknowledged document which has been received by the Gram Panchayat, that has also been enclosed along with this document. So, for the instruction of the Panchayat Samiti, along with the acknowledgements. In view of the above, the pair of Messrs. Shaktipada Kundu, MR Distributor, Notun Bazar, Arambagh, for replacement of the 30 metric ton of rice and making good of their sufficient stock arising out of the so-and-so is forwarded to, so for your kind consideration, forwarded for replacement of the rice. So this is the instruction. This has never been denied. Addressing to the so-and-so. Your Lordship need not go through all the documents. Kindly come to the next page. All together, I am requesting the district controller, along with the all documents, including the letter of the subdivisional controller, Panchayat Samiti, acknowledgement, everything. These are going on. Then I kindly take up my supplementary affidavit. Kindly take up my supplementary affidavit affirmed on 1st April 2025. This is the second one. Kindly turn up, my lord. This has been affirmed on 1st April 2025. This is the second supplementary affidavit.
Yes.
But kindly turn to page, my lord, 8.
Yes.
State, sorry, my lord. Kindly come to page 12. Extremely sorry, my lord. Well, this is an inquiry report. After filing the writ petition, when direction has been given for filing affidavits and adjournment has been prayed for on behalf of the state, this inquiry has been conducted by the food officials in my godown, which will appear from page 12. Kindly see the date, right-hand side box, 8th of March 2025. Page 12, right-hand side box, the date of inspection, 8th March. Have you also got, my lord?
Yes.
Page 12. And my lord, a writ petition has been affirmed, which will appear from page 16 of the writ petition, 11th of November 2024. Writ petition has been filed on 11th November 2024. Direction has been given for filing affidavits. Adjournment has been prayed for. During pendency of the writ petition, this inquiry has been conducted on 8th of March 2025.
Yes.
Now kindly see. But kindly see the Remarks of the inquiring team. First, my lord, part 1 display. Glow signboard indicating distributorship displayed. Toll-free not for grievance redressal displayed. Category-wise opening stock of the day displayed. Whether dedicated office of the space availability, yes. Whether computer with internal available, yes. All are yes. Number of chambers 3. Then whether scrutiny of the bombs walls, boundary wall, yes. Whether covered under CCTV, yes. Whether storage condition is satisfactory, yes. Then bottom last table, whether damage is being used, yes. Whether stocks of the waste one so and so, this is also yes. Then kindly turn the page. All yes. You will also kindly see the next box. Whether daily stock register, whether daily sale register, all are yes. There is no irregularity or illegality so far the inspection is concerned. Then my lord, not applicable is there also. Then kindly turn the bottom portion, serial number 33. Describe the improvements, describe the deteriorations. Shortfall of rice reduced gradually. Have a look, got my lord? Then overall opinion. There is a overall shortfall of so and so quintals of rice, but no storage on atta. But no shortage of atta. Have a look, got my lord? So far the atta is concerned, there is no shortage, only rice. But this is the result of the non-replenishment of the rice, which I have delivered and distributed through the subdivisional control and the Panchayat Samiti. Now, your lordship, kindly come to page 8. This is the communication dated 8th March 2025. I have shown to your lordship, inquiry has been conducted on 8th March. On 8th March itself, an order has been passed. Kindly take note of 8th March inquiry, 8th March communication. Kindly turn the page, kindly see my lord, page 9. This is kindly see the date 8th March. Well, I'm reading from serial number 5, paragraph 5. During physical verification of stock, so and so quintals of rice and so and so quintals of atta have been found as shortage in respect to the stock as on book balance. Have you also got it? Now kindly turn the penultimate paragraph at page, my lord, 11. Calculation, middle portion. Quantity of public distribution systems commodities found misappropriation and siphon on so and so quintals of rice. Economic cost so and so, total economic cost so and so, question rice so and so, district control so and so. So, my lord, a fine has been imposed upon me. Kindly see, it will appear from the page, my lord. This page also, the amount is recorded, my lord. Kindly see, total economic cost. The last paragraph, accordingly, MR distributor Shaktipada Kundu so subdivisional district Hooghly is instructed to deposit a sum of rupees true cost 61,25,000 as the shortage of rice, because they have also stated in this order at page, my lord, 9 that there is no shortage of atta. If you want to kindly turn to page 9, serial number 5. At page 10, 5th paragraph, so far as shortage of 365.69 quintals of atta is concerned, it was submitted that in view of the urgency of immediate delivery of the same, have a lordship, my lord, at page 10, 5th paragraph, it was submitted that in view of the urgency of the immediate delivery of the same, to the MR dealer, they dispatched it without online entry, for which the quantity was not physically available in their godown, and the inspecting officials found shortage. On the day of hearing, they produced the copies of the online challenge hearing signature of dealers as acknowledgement so and so. The fact corroborated with the figure available in the departmental portal, and hence the charges regarding shortage of stock of atta are dropped. So far as shortage is concerned, what was the allegation that has been dropped? And I have been directed to deposit a sum of rupees 2 lakhs, true cost 61 lakhs. If you also kindly take 3 pages of my writ petition, 2 pages from writ petition and this order, page 31 and 32, the fine amount 7.979 lakhs and true cost 61, and divided it by 3, the amount will come, the purchase price of 30 metric ton of rice. Because your lordship knows according to the control order, if there is a siphoning or misappropriation of food grains,
Three
then
times.
the market price three times. 3 times. If you take the money 7 lakhs or 9 lakhs and 2 or something and divided it by 3, it will come to a figure which market price is quantity of rice is 30 metric ton.
My lord, with leave of my learned senior friend, my lord, Mr. Sengupta is engaged in 11. My lord, I was also engaged. My lord, I took leave and came, my lord, to pray for a Passover.
I have already started the.
I understand, my lord, but the issue is that, my lord, we have taken the points of maintainability. My lord, so, my lord, if my learned friend, my lord, senior friend will argue on the merits of the case, before that, lordship may decide the question of maintainability. Otherwise, my lord, court's time will be, my lord, unnecessarily spent on the matter. If today I do not get, and my lord, junior take boleche o bolte pare bhoy paয়
আমাকে এসে
and my lord, we have filed, my lord, they have filed a supplementary affidavit to which we have prepared a second report.
Item number 14 there.
They are item 14, I am 13.
They have also placed some.
My lord, because my lord, it is aligned, and my lord, the issue of maintainability because appellate remedy being available.
Yes.
My lord, first
In the
appeal, second
supplementary
appeal, both are available. My lord, in case they are suffering a penalty, they can go up in appeal. They have
Yes.
not
That we have taken in our
approached that, yes. So, my lord, that is the point of maintainability. Perhaps it will anyone to everyone's benefit. If my learned senior friend, I have deepest of respect for him.
After vacation, any day fix it.
Yes, ma'am.
I have also taken each
Copy.
and every paragraph that has been taken by my learned senior friend in his
And my lord, this
petition,
report will be kept
everything.
on the record, which is my lord, the second
এই
report.
report দিয়েছে।
না না তোমাদের আগে একটা তোমার রিট পিটিশন ছিল, একটা অ্যাফিডেভিট সাপ্লিমেন্টারি ছিল, সেটার বিরুদ্ধে একটা রিপোর্ট ছিল, আর সেকেন্ড টাইম তোমাদের আমাদের উপর রিপোর্টেরই ডিরেকশন ছিল। সো উই
সেটা আমরা দেয়নি।
হ্যাঁ
ব্যাপারটা দেখে নিস একটু দিকে।
হ্যাঁ হ্যাঁ না না জজ সাহেব স্যার
Second report in the form of affidavit, item number 14.
মাই লর্ড আই এম গ্রেটফুল দিস ইজ শক্তিপদ কুন্ডু 27966
One is SP Kundu, another is Shaktipada
One
Kundu.
is
So
SK Kundu and
difference
one
is
is
there.
Shaktipada.
Difference is there.
আমি আর কপি পাঠিয়ে
বাবা,
কপি দিয়ে দেবো কোনো
So only maintainability is in respect of appeal available is there.
In my affidavit, I have also gone into the merits of the case and
question is my lord they are not happy with my lord's penalty being imposed. My lord, that is my lord
you are very much
applicable.
happy with the penalty. Our case is replenishment of the rights.
Anyway, my lord,
There is no permission for it. Let them out.
without going into that, my lord, keeps it any day after the vacation, as my learned senior friend has suggested.
Both the matters after vacation.
Grateful, my lord. That may
Only recording matters are. Otherwise,
part heard.
Yes.
I mean, yes, we will get some.
No, that's fine. That's fine. I have no.
Two separate orders, your lordship.
No, you have preferred affidavit in opposition.
Yes,
Affidavit in opposition. Item number 13.
30.
Item number 13 telephone. Affidavit in opposition by the state respondents
report ছিল
against supplementary affidavit filed by the petitioner.
So
এই
today,
জন্য report
1st of April 2025 is taken on record. Full stop. Matter heard in part.
এক্ষুনি কপি পাঠিয়ে
Let the matter appear in the list on
কপি আছে
মানে after 1 week from the vacation.
আমি 18 জুন পর্যন্ত পাই।
18th. 18th, you are there?
Yes, sir.
19th.
ঠিক আছে,
No, 19th is the
One-
Thursday.
No, as your lord,
19th is the Thursday. 18th is
because
the
I will
good
be
thing.
out of station,
Very well.
that is why I said.
18th under the heading 2 women.
Same position, my lord.
Say another heading 2 women.
My lord.
Very well. Hello. But next likho. 14.
My lord.
Second report in the form of affidavit filed on behalf of the state respondents against the supplementary affidavit filed by the petitioner is taken on record. Matter heard in part. Let the matter appear on 18th of June 2025 under the heading 2 women.
Very well.
Heard in part.
My lord.
Very well, lord. Grateful to your lordship. Sorry.
আরে ঠিক আছে।
ও বলতে পারে
Order recording করবো। So many things.
अरे बाबा, काश कि उस लायक होते हैं।
Next.
Can it taken up after vacation?
On Thursday, we have filed our opposition, my lord. Kindly record it.
My learned friend could not.
Let the matter appear after vacation. After 1 week of vacation.
They will file opposition, we have to file reply. Time maybe it's
My lord, my lord, on Thursday, my lord, we filed our opposition, my lord. That has not been recorded in the order.
Right.
আজকে রেকর্ড করতে হবে।
Affidavit in opposition file on behalf of respondent number 1 to 5 is taken on record. Full stop.
Copy sir.
Copy of the affidavit has already been served. Full stop. Next para. The petitioner as well as the private respondent is at leave to file reply to the affidavit in opposition within 2 weeks after vacation. List the matter.
Now in the meantime তোরা ফাইল করবি না application? The time নেই।
I also file. Yes, leave is granted both of you to file.
So far
No
their
object.
opposition
You have
not
not
filed.
preferred any opposition. Okay.
so far the petition is concerned.
They'll have to
Okay.
file reply.
The private respondent also is at leave to file affidavit in opposition against the writ petition within 2 weeks after vacation.
And 2 weeks time it is given to file reply.
Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list. Parties are elevated to mention.
Okay.
Next.
16 Lordship, I am appearing on behalf of the petitioner
Yes.
and we have of the respondents. Lordship, at the outset, I beg to draw the kind attention of this honorable court that my father was dealer and he expired. And after his demise, we made an application and that application has been not entertained arbitrarily.
Where is your application?
My application, Lordship.
Your application for compassionate appointment?
Yes, Lordship.
Where is your application?
That is, Lordship, annexure, a copy of letter dated 16/5/2024, page number 36, and representation dated 15/4/2024 is on page number 32. And Lordship, our honorable coordinate bench has already decided this issue. So at the outset, I would submit this judgment before this honorable court. Our coordinate bench has already decided this issue earlier in 2 different cases.
So grandmother was the license holder in that matter.
And in
Mohammed Arab.
Arab Lordship, in Arab matters.
No, who are you? You are the sons.
Yes, Lordship. I am the son. And all the legal heirs have already given the NOC. All the legal heirs.
Where is the NOC?
NOC, Lordship, a copy, NOC has already been given to the concerned authorities.
So what is your grievance now? What you want? What is your grievance now?
My prayer is, Lordship, to allow me to run the shop of.
Whether the decision has been taken by the authority to granting license?
Yes, already. Lordship, our shop is already going on.
So what is your prayer now?
And the authority concerned has rejected my prayer arbitrarily.
Have rejected. So, what is the order?
Rejection order I have already annexed, Lordship. That is on the annexure, a copy of letter dated. What was it, Babu? Page number 26, Lordship. At page 26. At page 26.
You have failed to produce no objections.
No, already we have given one, our stepmother was declined at earlier stage, and subsequently she had given the NOC, and that NOC has been considered by the concerned authority on 15/3/2024. We have given the no objection in list of dates, Lordship. 15/3/2024,
Order has already been passed in the year February 2023.
Lordship. And after that,
Then the matter has already been decided. Thereafter, how can you place the no objection?
after that, we have given the representation on 9/12/2024. 9/12/2024. Page number, Lordship. Our
32, you said.
32, Lordship.
So after rejection, you made a representation.
Lordship, if the rejection is illegal and arbitrary,
how
law has been set at rest by this honorable coordinate bench. If the person has died, if his son or daughter is helpless, he can apply and he is entitled to get.
So there are some preconditions.
True, Lordship.
Then
I am relying upon the judgment and the relevant para, Durga Das. This our honorable court.
Are you challenging that order? 16th of February 2023, this order, or you want your representation to be heard?
Considered.
What you want?
Lordship, in fact, I want justice in
No.
any ways and manner.
I know you want justice. Now, by which way you want to press?
If my representation will be considered, it's also good for me.
No, you have not challenged the order.
I have challenged that order.
You have not challenged the order. That is 16th of February 2023 order. You have not challenged in the writ petition.
We have challenged, Lordship.
Which prayer?
Our prayer number C, Lordship. Mandamus commanding the concerned respondents to withdraw and cancel or set aside the order of the rejection of the petitioner's application for appointment on compassionate ground. At page number 13, Lordship.
Page number
13 in my prayer.
No. What is the date? 20th of November.
2011/2024.
Which page?
Page number 13 of my writ petition.
No, I have got your prayer.
A prayer.
Where is the document? 20th of November.
Page number 41, Lordship.
Page number 41.
41.
আচ্ছা এটা কি আছে বলো তো?
Annexure P11, Lordship.
If you challenge that order,
Lordship.
I have to call for a report from the state.
Lordship.
Okay.
Lordship.
Otherwise, if you want your representation to be
I
considered,
am opposing both
Report, Lordship,
prayers, Your
report.
Lordship. Why report?
this is the issue now altogether. Okay. So let me hear out. Yes.
Lordship.
Why report both the prayers I am opposing, Your Lordship? Representation also should not be considered. Kindly see page number 32 once.
Page number
32, P7. 16. Second paragraph.
Yes.
Kindly see কি লেখা আছে একটু help.
আমাদের পিতা গত ইংরাজি 23/3/2016 তারিখে পরলোক গমন করিলে দুই পুত্র মুক্তার সর্দার মুর্তাজা সর্দার. What has to be noted is the
date.
और
ऊपर एकटा दिखाओ.
And the letter, the date on top.
15/4/24.
After 9 years.
This is the representation.
Yes, they are coming after 9 years. Point number 1.
So prior to that, an order has been passed by the
24, 23, that order is already that my learned friend had shown.
So they are challenging that order
Yes,
now.
they are challenging, not appropriately also challenging this order. They are making a representation after the game is over. And we had made a notification with respect to a resultant vacancy. 20, I will, in my,
Yes.
my first, can you hand over the instructions?
Yes, but it is not.
That doesn't matter. I will just.
I'm just having my copy.
Second page, your lordship. Very briefly, I will. For clarity of the matter. During the hearing, first page, second page. During the hearing dated 29/9/2022, as lordship got it. Only the applicants, being Mukhtar Sardar herein, the petitioner, and Mortaja Sardar attended, and they declared that they will submit NOC from all legal heirs within 11/10/2022. They failed to submit the same within the stipulated time. Annexure P4 hearing sheet dated 29/9/2022. Then another hearing. Another hearing was called on 19/12/2022. Vide memo number this dated 15/12/2022. On the hearing dated 19/12/2022, Regina Baby, the stepmother of the petitioner, was absent. During the hearing, it was found that 3 legal heirs, Mabia Bibi, Rabia Bibi, and Regia Bibi, out of 4 have submitted their NOC in the form of affidavit. But Regina Baby, wife of late Abdul Bari Sardar and stepmother of applicants, has not given any no objection to process the case file in favor of the applicants. Annexure P5 NOC annexed. Then the instant case file was forwarded to the concerned authority on 3/1/2023 for taking necessary action. The application of Mokhtar Sardar and Mortaja Sardar has been rejected by the department, and also it has been instructed, vide dated 16/2/23, the order to declare the resultant vacancy. Accordingly, an FPS vacancy notice was issued, vide memo number this dated 24/3/2023, but yet not published in the newspapers till date. Then subsequently, the procedure follows. Now a question that I'm bound to ask myself, after giving so many opportunities of hearing, they were first asked to produce the NOC within a stipulated period of time. They fail. Second time they come, again they fail. Now, how long are we supposed to wait, your lordship? First representation, father has died way back in the year 2015 or 2016. They are coming way in 22. And in 24, everything gets over, and then they make a representation saying that this has not been done in accordance with law. So you please consider my representation. The question that I'm bound to ask myself, what remains? What survives? Yes. Kindly sees 29/9/2022. That is, I do not know. 1 minute. Page number, that is 56. 57. It should be personal hearing.
There's a form that they have submitted.
And this for making it
57
clear.
of
Verse 57.
57 of
Oh yes, it's our report. That is, where is 56 is, I have pointed out, it's read there in the order. Personal hearing held on 29/9/2022. Kindly sees this towards right, point 3. ওটা পড়ে দাও তো।
আপনারা সকল লিগ্যাল এডদের এনওসি জমা করতে পারেননি। আগামী 11/10/2022 তারিখের মধ্যে ইগল এয়ারের এনওসি জমা দিতে হবে, অন্যথায় আপনাদের কেস রেজাল্টেন্ট ভ্যাকেন্সির জন্য পাঠানো হবে। আপনাদের মতামত কি? দেয়ার রিপ্লাই, আমাদের একজন লিগ্যাল এয়ারের এনওসি জমা দেওয়া বাকি আছে, সেটি 11/10/2022 মধ্যে জমা দিব, অন্যথা আমাদের কেস রেজাল্টেন্ট ভ্যাকেন্সির জন্য পাঠালে আমাদের কোনো আপত্তি নাই। This is a declaration that they have given. উপরের বক্তব্যটি আমাদের নিজস্ব, আমরা জেনে বুঝেই সই করিলাম।
What are you reading?
Show me the page. এইটা দেখিয়ে দিন। আমি যে what report I have submitted.
Just submitted my copy
Yes.
of the report.
রেজিনা বিবি দিয়েছে ওদের কোথায় আছে? হ্যাঁ 29:30, na?
Regina Bibi is the second one.
Yes, Lordship.
Yes.
At page 30, she has given the no objection.
But when it is coming, that
Lordship,
is also is need to.
I beg to draw your attention here that at page number 18, the authority concerned directed me, the undersigned, to submit the required documents as per the checklist. So authority has already allowed me, Lordship, at page 18, Lordship.
Date
At page 18,
2022.
authority has already allowed me.
18.
Page number 18, annexure P,
22.
15/9/2022. And still the shop is running, Lordship.
Who running the shop?
Petitioner is running the shop.
You are running the shop?
Yes, Lordship. And there is no any adverse report. Our coordinate,
Are they running the
our
shop?
coordinate bench specifically held it.
Can they run the shop?
First, you see.
After-
Abdul Bari Sardar, FPS dealer, village Ramnagar, is leaving 6 legal lesson.
It has to be tagged with another FPS.
Yes, resultant.
Why? How they are running the shop?
That we are not
Sure about.
we are not sure about. We have to
Take instructions.
regarding that.
Whether the
Call for the report, Lordship.
by report.
Report is indispensable, as because if the respondent is not sure,
See your report. You see your report. The last but no, this document. This document.
Yes, which I had pointed out.
Last but one document, I think. Pagination is not there. Some hearing was taken in respect of Regina BB.
exactly, Lordship. Obliged.
April 2022.
2022, 29/9.
29/9.
No, 26th of April 2024. 26th of April 2024. Subdivisional controller. Bengali written.
Last day दिखे वो मेरे को तो FPS vacancy notice আছে
এটা
8/3.
8/3/24.
26th of April 2024.
Oh, this is Regina.
Bengali written.
Yes, we have got 6. Yes, কি লিখা আছে
পারিবারিক গন্ডগোলের
লাস্ট ডে দিকে দেখো
যে সময় এনওসি দিই নাই বর্তমানে আমি এনওসি দিলাম ভবিষ্যতে এই অবস্থা
You read the title, personal hearing in respect.
Regina BB, second wife of Abdul Bari Sardar.
and the applicant 26/4/24 at 12.
So why entire matter after closing entire matter again hearing was admitted?
Obliged, Lordship.
Yes. Let us come back.
Yes, let you come back with the report.
With the report.
Please take down. Present petitioner.
नाम लिखे देना विशाल
Petitioners are the sons of erstwhile Emmer dealer. What is the name? namely Abdul Bari Sardar,
Abdul Bari
who expired in the year 2016. Full stop. Expired on 23rd of March 2016. Full stop. After his expiry, the present petitioner applied for license on compassionate ground. They were heard, they were directed to produce certain documents which they produced. Thereafter, their application was turned down by the concerned deputy director license. Concerned deputy director license by an order dated 16th of February 2023. Full stop. It has been contended in the order that the petitioners could not produce no objection certificate from all the family members. The present petitioner placed the no objection certificate of second wife of the erstwhile lemma dealer, and accordingly an hearing was conducted by the concerned authority on 26th of April 2024. Full stop. 26th of April 2020. Since then, the respondent authority has not taken any stance, hence this writ. Having heard the learned counsel for the parties on also considering the report, considering the documents placed by the documents containing brief case history placed by the concerned subdivisional controller, it appears to me that the state authority must be given an opportunity to submit a report in the form of affidavit. Let the affidavit be filed within 3 weeks after vacation. 3 weeks after vacation. Reply, if any. 4 weeks after vacation. 4 weeks after vacation. Reply, if any, reply, stroke exception, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list. Party is liberty to mention.
Lordship deeply obliged.
Affidavit in opposition file on behalf of the petitioner is taken on record.
Lordship, may I have my instructions?
I have noted your instructions.
ठीक है. We will get it. Grateful, Your Lord.
Yes.
Deeply obliged.
Next.
I'm for the item number 70. I'm for the petition, Lordship. The last occasion, Lordship called for report in the form of affidavit. How many cards has been deducted from my
The report is being affirmed today itself, my lord. If it is adjourned for the day, it can be given the later part of the day, it can be handed over.
Tomorrow not possible.
Lordship, then it keeps it on the reopening of the date.
Yes.
But
Mr. Dotto, learned senior counsel appearing on behalf of the state respondent, the report is that the report is supposed to be shown before this court today. Having heard the matter, having heard the learned counsel, having heard Mr. Dotto, let the matter appear in the list in the second week of June 2025 under the same heading.
Lordship obliged.
Next.
Lordship. We appear on behalf of the state respondent.
Yes.
My lord, I appear on behalf of the petitioner. The impugned notification which is under challenge is at page 34. But as of now, my lord, there is not much scope of an interim order. This is pertaining to the fair price shop, my lord, where in terms of the 2021 policy, that shop minimum catering amount, my lord, was 6,000 to 7,500. So this is the Duare ration scheme, my lord, which is carried out. So, my lord, one shop, because my lord, this minimum amount was fixed, considering the viability of the person concerned who is giving the service, and also, my lord, it's a social cause where, my lord, the ration is being delivered to the doorstep of the consumer. My lord, page 34, lordship will find the petitioner, my lord, already carries on, my lord, it's running an FPS, a fair price shop in that area. Lord, by this notification, my lord, in my area, a new shop has application for a new vacancy has been declared. Now, this in my respectful submission is in violation of the 21 policy,
and the subsequent modifications thereto, my lord, there are jurisdictional issues which I shall submit. But as of now, all I am seeking is, my lord, in terms of the guidelines, if lordship comes to, my lord, page 27, I'm sorry, page 28.
That is 21 guideline.
Yes. My lord, page 28, my lord, they, under rule 5.
Yes.
After receiving report from the concerned area inspector, SCFS will prepare suitable vacancy. So, my lord, since I am challenging this, my lord, as of interim order, let them by affidavit, my lord, disclose this report. Because, my lord, in that report, I will get, my lord, what is there at page 30 is the format. What is the basis of that? Because, my lord, I am saying that the basis of this notification is arbitrary. When, my lord, I am already having that minimum 7,500, 760. What is the basis of again inviting another shop just to cut my business, which affects the viability? Because, my lord, the guidelines was formulated keeping a balance between a viable FPS and, of course, the convenience.
Yes.
And here, my lord, the rationale that, my lord, it will be nearer, it doesn't apply because it is duare ration. Ration is being delivered to the household of the consumer. So it is not that the consumer will have to walk and go over
collect
there.
the.
So it is being delivered. And there is no complaint of, my lord, that service is not being done so far as my client is concerned. So all I am seeking, let them, my lord, give that, my lord, report.
We'll certainly file a report, but my lord, what my lord, I submit that, my lord, right now the petitioner's foreign fair price shop is overpopulated with, my lord, 7,000.
Then you submit a report.
Lordship, my lord.
Okay.
Yes.
Please take down. Petitioner is running a FPS.
Within 1 week after vacation, if it pleases,
yes,
if they can submit the report, my lord, in terms of
within 1 week, my lord, that would be possible. My lord, vacation I
so we come within 2 weeks.
2 weeks.
2 weeks already.
Okay.
In terms of rule 5 of the guidelines.
But we would file a comprehensive report, my lord.
Yes, yes.
Yes, we would file a comprehensive report. Thank you. বলে দেবো আমাদের রিপোর্টে।
হ্যাঁ বলো কি বলেছি? petitioner is running a FPS shop, fair price shop at village Dharmpur, PO Dangapada, district Murshidabad, within Mauja Dharampur, having lawful possession of godown space at plot number 947 under the same Mauja. Okay. Full stop. It is the contention of the petitioner that he is performing business following the relevant guidelines of the state of West Bengal, of the guidelines of the concerned department, by providing and supplying ration articles at the doorsteps of the beneficiaries within bracket Duare ration scheme, under Duare ration scheme. Full stop. Suddenly, the concerned subdivision controller Lalbagh, Murshidabad declared a vacancy notification by memo number 1123 stroke SCL stroke MSD stroke 24 dated 26th of December 2024. It is the contention of the petitioner that the declaration of vacancy by the subdivisional controller is violative to the guideline issued by the government of West Bengal dated 3rd of September 2021, and by such notification, if any person was appointed, the business of the petitioner would be economically viable. Full stop.
My lord, my submission is this, my lord, that we have issued this order in terms of the guidelines and also, my lord, in conformity with the order. If your lordship kindly looks at page 33 of the, my lord, government order dated 28th March 2022.
Okay.
And right now, my lord, petitioner fair price shop is overpopulated with 7,652, my lord, DRC, and only, my lord, 2,670 DRC will be carted from him with, my lord, permission of
You submit a report, detailed report thereafter
Yes.
this matter. Learned counsel appearing on behalf of the state authority submits that the vacancy notification was issued, was published in terms of notification dated 28th of March 2022, and the DRC of the present petitioner is overpopulated. Having heard the learned counsel for the parties, it appears to me that the instant matter cannot be disposed of without giving an opportunity to the state respondent to file a comprehensive report. Let the report be filed within 2 weeks after vacation. Reply stroke exception, if any, by the petitioner within 1 week thereafter. List the matter at the 3rd week of June 2020.
report in the form of an affidavit.
Report in the form of it.
Only one clarification, my lord. Let them file report in form. Let the report also contain the report in terms of
file a comprehensive report. We will file
I mention it. Okay.
in terms of, my lord, para 5 of the guideline. That is very important.
Okay. কি বললাম বলো? Let the তারপরে পড়েছি বলো।
My lord, we are, my lord, doing it in terms of the guideline, my lord, issued in
cannot be
the
disposed
year
of
2024.
Without giving an opportunity to the state respondent to file a report. Full stop. Let the report be filed by the let the report be filed.
My lord, we are, my lord, we have issued this, my lord, order in terms of this guideline, my lord. My lord, guideline, my lord, that is, my lord, notification dated, my lord, 1st August 2024.
24 guidelines.
So we would file a comprehensive report, my lord. Your lordship would not mention, my lord, we would file a comprehensive report.
কি বললাম বলো? Report containing justification to issue the notification,
lordship,
and also explanation to that of the 2021 guidelines.
No, guidelines. There are several guidelines.
As well as the relevant guidelines to the effect. As well as
all the relevant and necessary guidelines. Relevant and necessary guidelines.
As well as the relevant and necessary guidelines to the effect.
Lordship.
Necessary and relevant guidelines to that effect.
To that effect. Grateful.
At the end of the day, it will boil down to whether orders can modify guidelines or vice versa.
Yes.
Guideline is one, orders are coming year after year. Whether the orders can be contrary to the guideline.
Yes.
That is one.
That is the merit.
That is the merit.
That is the merit, Lordship. Yes.
Lordship, all the other matters, Lordship, are similar as the item number 18, which has been just conducted right now, my lord. I will pray for similar order, my lord. All the matters are same. All.
Which matter?
We'll just mention it in the slip and we'll just submit it.
Which matter?
I am in 19. 19 has been called on, I am in 19.
18 to 24, my lord, are same matters.
One by number, unless number is called on.
Mr. Dotto, you are in
I'm in 19.
18.
No, I am in 19.
My lord, I am appearing in item number 21, my lord.
Just wait, let me call one after another.
Yes, that will be better.
My
So,
lord.
what you were saying, item number 19 to 21.
24.
19 to 24.
Yes, my lord.
Just wait, I will call one after another. So, what is the item number 19? Mr. Dotto, you are item number 19.
I am in 19.
What is the matter?
Place vacancy notification.
Lordship, it is the same matter, Lordship, vacancy notification under the control order 2024, my lord. Same as item number 18.
Okay, where I seek the report.
Yes, yes.
Yes, yes, Lord. Yes, right. Yes, yes, my lord.
Okay, same order.
Same order.
Or submit a comprehensive report in the form of affidavit
Very well.
within 2 weeks after vacation.
No, Malad, let it be 4 weeks after the vacation because in the beginning holidays will be there.
We shall not be there. Just wait.
To wait.
So what we want? 3 weeks
4
after
weeks.
vacation? 4 weeks.
If it is 4 weeks after the vacation, it's good for us.
My lord, but in item
after
number 18, my lord, the same direction has been passed. 2 weeks is more than enough, my lord. I
It
feel.
is not more than enough for us. That's why you are praying for that.
But right now, an order
Very
had
well.
been passed.
3 weeks after vacation.
My lord, regarding item number 21, my lord.
Our right.
Same direction যেটা আছে তাই থাকবে economically viable like that on justification to issuance of order ওটা হচ্ছে শুরু করবে 3 weeks after vacation reply if any by 2 weeks thereafter let the matter appear in the last week of June 2025 under the same heading.
Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. This is item number
19.
Yes, next.
This is the same matter, my lord.
I'm for the statement.
Keep the name. Affidavit in opposition.
I'm sorry.
Item number 20, similar order. 3 weeks after.
Lordship, I appear for the petitioner, my lord. I'm very sorry to intervene, my lord. The only thing that I'll be praying for, my lord, Lordship gives them only 2 weeks time as item number 18, my lord. The reason being, my lord, that, my lord, all that they would submit in the form of report, my lord, is what that is already there in their files. My lord, without, my lord, clause 5, this vacancy notice could not have been published because clause 5, if your lordship sees, my lord, it
Let them
speaks about the
justify.
reports.
Let them justify by filing a report. So report when can it be
Yes,
filed?
yes, yes. They will file a report. I'm not even
Within
praying
2
for
weeks.
your lordship gives them 2 weeks time because
3 weeks after vacation. Before
well, it is
6
already
weeks
there
cannot.
in their files.
After 3 weeks, vacation.
It is already there in
Okay, very well.
the
3 weeks
files.
after vacation. Similar order.
Without which
3 weeks, 2 weeks.
they all that they need few hours work.
They are difficulty. There are reasons for difficulty.
My lord, regarding this matter, I'm appearing, my lord, regarding item 21.
It is the same matter, my lord. Similar order could be passed.
My lord, my learned junior will hand over the report, my lord. There is my lord, already new place of vacancy is, my lord. No, it is not the similar matter. My lord, kindly hear me out. Let me place my case. Do not misrepresent in the court. My lord, new place of vacancy is Char Devipur Masjid, PS Bhavan Gola. And vacancy notice had been declared as Annexure B, my lord. Whereas it is seen that petitioner if PS is overpopulated with 6921 DHC at present and only 2077 DHC will be curtailed after fresh vacancy. It will be written maximum DHC that is 4844. My report, my lord, third page, paragraph 70.
You submit a report in the form of affidavit by serving a copy to them. Similar direction.
My lord, 4 weeks, my lord.
3 weeks.
My lord, 4 weeks kindly, my lord, because
Report is with your hand. Now you are saying 4 weeks. Why?
My lord, I have to go out of
Can
station.
be, affidavit can be shown within a week. You place
My
the
lord, I have to go out of
all
India, my
similar
lord,
order
for that.
3 weeks after vacation. Next.
Grateful, my lord.
Similar matter, my lord.
My lord, may I file a report?
No, report you have to file on the affidavit, okay?
Affidavit.
You have to file on report on affidavit. In the form of affidavit, you place the report so that they can contradict.
Lordship.
Okay?
Lordship.
Within 3 weeks after vacation.
3 weeks.
within 3 weeks after vacation, reply exception within 2 weeks thereafter. Last week, it will appear at last week of June. Yes, next.
My lord, I am appealing for the state, my lord.
Similar matter, my lord, affidavit of service.
Similar direction. Report within 3 weeks after vacation. Report exception 2 weeks thereafter. Madam, you are there in the 24. Similar matter?
Yes.
Okay, similar direction, 3 weeks after vacation.
It's a different matter.
In item number 25, Lordship, I beg to appear on behalf of the petitioner, Lordship, challenging the order, Lordship. There is appeal is pending, Lordship. Let the matter go out of the list, Lordship. Subsequently, liberty to mention, Lordship.
Already preferred an appeal.
Control order 13 ache na?
However, he has already preferred an appeal with the authority.
No, that is what I'm asking. One look at the report says that it is 2013.
There was nahi to tumi added party. No, Lordship.
It's a partnership firm that I believe. Hey, Kintu? Ki ache? Rather than an application
Lordship,
for
in earlier
reconstitution
occasion,
of the
Lordship,
partnership firm.
that was withdrawn. No, Lordship. The subject matter of this matter is, Lordship, different.
Yes.
Oh, I stand corrected, Lordship. In this matter, Lordship, the petitioner is applied for a vacancy. He is the in earlier occasion, Lordship, there is a Lordship, the petitioner with a license, and subsequently the license has been due to sad demise of one partner of the partnership firm, Lordship. Subsequently, they applied for the license. Now, Lordship, will come to page number 46. Lordship will find the representation that is made by the petitioner, Lordship, that আমার বিনীত নিবেদন এই যে আমি আজহার হোসেন সাচানসা যাহার এফপিএস লাইসেন্স নাম্বার সাচানসা যাহার ঠিকানা গ্রাম গোবিন্দপুর পোস্ট অর্জুনপুর থানা গাজল জেলা মালদা আমি আজহার হোসেনের প্রথম অংশীদার ও আমার মা সাপেরা খাতুন দ্বিতীয় অংশীদার ছিলেন, কিন্তু গত ইংরাজির এত তারিখে দ্বিতীয় অংশীদার আমার মা সাপেরা খাতুন নিজ বাসস্থানে পরলোক গমন করেন। মার মৃত্যুর পর আমার জায়গাটি দ্বিতীয় অংশীদার হিসাবে আমি আমার ভাইকে পার্টনার হিসাবে অন্তর্ভুক্ত করতে চাই। অতএব মহাশয়, আপনার কাছে আমার বিনীত বিদায় প্রার্থনা, অনুগ্রহ করে আমার এই আবেদন মঞ্জুর করিতে বাধিত থাকবেন। Now, Lordship, there is an existence of FES license, and the petitioner that was running under the partnership firm, and subsequently one partner has after the sad demise of the one partner, the license has then after, Lordship, I have applied for the FES license. Now, subsequently, in my periphery, Lordship, there is one vacancy has been declared. Without considering my application, Lordship, they have declared a FES vacancy and they trying to give a license to someone who is going to apply against the vacancy notification. Now, my lord, my prayer is simple, Lordship, to consider my application, and subsequently, in the meantime, no third-party rights should be created.
Now,
That is my humble
may
prayer.
I humbly submit?
No, I can.
Lordship has dealt with a similar.
representation
No, not similar issue never been dealt with, Lordship. In earlier occasion, the matter was filed. It was liberty was given to withdraw and file a fresh, Lordship, because the contention of the writ application was there is some fact has been narrated in the writ application mistakenly. What was stated that he was with the license, Lordship. Now, so far the instruction is concerned, he don't have any license right now, because as the license was given to a partnership firm and sad demise of a particular person, Lordship, there is no existence of valid license till now. As I have applied in the same vacancy for the renewal of my license to give the fresh license to me, Lordship. Now, subsequently, a vacancy notification has been issued in the same periphery. Now, Lordship, if a license would be given by a fresh vacancy to someone else, Lordship, then my right will be curtailed, Lordship. Now, Lordship, in the meantime, Lordship, my already in progress, my application in progress. I have applied before them. So far, the procedure is concerned, and now they are further issued a fresh notification for the appointment of new FES license, Lordship. So my prayer is restricted to that point, Lordship. In the meantime, let them consider my application, and in the meantime, no third-party rights should be created in my periphery, Lordship.
Where is the new vacancy notification?
Lordship, that is annexed, Lordship. Lordship will come to page number 51. Your Lordship will find that that vacancy notification is there, Lordship. In my petition also that has been narrated, Lordship. That vacancy which has been declared, your Lordship will find for page number 5. Page number 6 onwards, Lordship, at paragraph 5.8, Lordship. Your petitioner state that on 29/4/2024, the Office of the Subdivisional Controller, Food and Supply, Malda, issued a representative to the petitioner via such and such, calling for hearing of such and such. And now, paragraph number 9, Lordship, your petitioner state that to the utter shock and dismay of the petitioner, a vacancy notification dated 10/5/2024, being memo number 441/SCFM/2024 was issued by the respondent authorities for the said fair price shop. The issuance of the vacancy notification disregards the pending application for the substitution of the new partner and violate the principle of natural justice. Lordship will find from page number 6, paragraph number 9, Lordship. I have stated. The fresh notification has been issued despite the pendency of my application, Lordship. My application may be rejected, may be allowed, Lordship. But in the meantime, they cannot issue a fresh license in my territory, Lordship. For the satisfaction of your Lordship, I have annexed all the document, Lordship. Your Lordship will find from page number 34 that the existing license, that earlier the license which has been annexed, Lordship, that is in page 34. And subsequently, Lordship, the partnership deed is also annexed, Lordship. We will find from page number 36 onwards.
So after demise of one of the partner, who is running the business now?
Now I am not running the business, Lordship. I have applied before them to substitute the name and induct my brother as a partner.
Is this the procedure that is usually followed? May I ask this question to myself? It is a very well-known practice that if one of the partner dies, there is a provision, it should be reconstituted.
Yes.
Yes. Then you are trying to submit something else.
That has been.
You are going before the authority. You are saying substitute this person as a partner and give me a license.
Is page number 48, Lordship, annexure T5.
The case has been put very differently, Your Lordship, and I take extreme exception to this.
If my application, I made an application, rightly or wrongly, if they are the authority, they can refuse my application, Lordship.
The question does not arise. First, it should be in accordance with law.
I am the partner of a partnership firm. I was running a fair price shop. Subsequently, one person died. So far the rules is concerned, Lordship, subsequently it has been struck down. So my right to apply a phrase, I write, and I also made the representation to them that I will induct my brother as one of the partner in the partnership deed, Lordship. That is
whether you have applied for reconstitution.
Yes, your Lordship will find from page number 48.
Where is it, Lordship? If suppose I am in a partnership, the word definitely says that yes,
Lordship,
not a single person is there.
Another thing is that, Lordship, kindly come to page number 49 at once, Lordship. That so far my application is concerned, they have asked for a hearing. That is annexed in page number 49, Lordship.
I have received instructions. Let my learned friend complete. I will.
Yes. So now, Lordship, after that application, Lordship, they have hearing in connection with the application of Azhar Hossain for engagement as a partner of Afzal Hossain of MS such and such, son and such, Lordship, compassionate ground in the place of late Safeda Khatun. That is the subject. Your Lordship will find for page number 49. Now, this hearing has been concluded. They have asked for the hearing. Now, what is the final output of the hearing? That has not been communicated to me, Lordship. Okay. In the meantime, they have made the vacancy notification, Lordship. Kindly consider this aspect only.
In my set of instructions.
Yes. Yes, Mrs. Sinha?
Yes. In my set of instructions which I have received, I would have handed over another set because my learned junior is not present today. I have received instructions dated the 16/2/2024, which writes to Azhar Hossain, village Govindapur, PO Arjunpur, PS Gazol, district Malda, consequent to the demise of Safira Khatun, one of the partners of the partnership firm, MS Tafajjul Hossain and son, MR dealer, bearing license number this of village Govindapur, GP Karkach, block Gazol, district Malda on 10/5/2023. The said MR shop was tagged with the FPS MS Saifuddin wait, Pintu, hold on for a moment. Saifuddin Sarkar and Sons on 17/1/2024, Vide memo number this in the interest of the public distribution system. The area inspector Gazol block has requested you to reconstitute the partnership firm. This request has already been made by our side. You to reconstitute the partnership firm by inducting only the family member of the deceased partner having no regular means of income and not otherwise. In this connection, you are once again requested to apply within 7 days for reconstitution of the partnership firm by inducting only the family member of the deceased partner having no regular means of income and not otherwise as per clause 27 of the West Bengal Public Distribution System Maintenance and on Control Order as amended. Please be informed that failure to apply as per relevant provisions of the said control order within the stipulated time may lead to declaration of resultant vacancy. Now, Your Lordship, someone who is practicing law, I do not know, they are appearing on my side, the petitioner side, attending big chambers. They know better law than what I know. I'm relying on what the instructions have been given to me. This is a very simple law that when one of the partner, the very essential name partner, it means one is not there, two are there. One has to die. Even in case of trust, this has to be reconstituted. And this is what the subdivisional controller has asked them, wider letter. Now, instead of getting the firm constituted with due process of law, they are saying, please, you consider my representation, this and this. Where is the reconstituted, the provision of law? Where is that, Your Lordship? I am supposed to you consider you in any form only and only if you are giving me certain provisions of law, you are abiding by it. What is not there, I cannot give you even an opportunity of hearing. Simple case this is, I fail to understand. It is very good that in the initial stage you said that it is 2013, it should go out of list. In the second stage you say that I should be given hearing. You apply before the authority.
Consider the page number 49.
First, you do appropriate.
My landed senior is submitting in
First,
connection with
follow
the
the
letter issued in sometime between 1st of February 2024. Now, I made the annexure at annexure P6, Lordship, that is issued on 29th of April 2024. Now, opportunity of hearing has been given.
I have read out
what
the
is the
letter.
stand of the subdivisional controller?
Or let the submit a report.
Why they have issued this? Why this opportunity has been given for the hearing? That has been issued by them. That is
only to tell you that you have not submitted your reconstituted.
No, that is not the subject matter of the notice. That notice which has been issued, Lordship, the subject matter of the notice is very simple. That hearing in connection with the application of Azhar Hossain for engagement
Lordship,
as a partner of Afzal Hossain of Messr Tofzal Hossain and son FCS dealer or compassionate ground in place of late
if the direction
Safera
calls from your
Khatun
Lordship to
Gazal
file a
Block
report. Hold on.
Not necessary.
Yes.
Now, Lordship, interim protection is required to be given, Lordship,
Why
because
protection,
no,
Your
Lordship,
Lordship, someone who does not qualify. Why protection?
that is their part, Lordship, they may reject me.
Why?
After hearing, Lordship,
You
they
are
may
not
reject
in
my
the
application.
consideration zone.
Admittedly, you have not applied
Yes.
for reconstitution.
I applied, Lordship. So kindly come to the hearing. That is subject matter of the hearing, Lordship. Kindly consider
I
my
am vehemently opposing the submission.
That is probably my learned friend is mistakenly places all those documents, Lordship. Kindly consider the page number 49 and
I
Lordship.
submitting
If
on
I
behalf
have-
of
if
documents which are duly signed by the officers. Please.
My lord, kindly come to page number 49 at once, Lordship. So far, this notice is concerned that has been issued as memo number 414 SCFM MR 24.
That's why I'm
dated
asking for
29th
report.
2012.
That is why I'm asking for
that
report.
has been given to all the legal heirs of the deceased person.
I have read it.
Yes, your lordship.
So you want to argue
without compliance with their report, their letter, lordship, this cannot be issued. That unless I have deposited some document, lordship, they cannot issue this hearing notice.
This has already fallen from your lordship that we have to place all our documents in the form of a report. ঠিক আছে? আমি শুধু বলছি যে একটা basic principle of law আছে.
I have applied.
Yes.
I have applied.
You have applied. For that, the whole process be stalled because you have applied. Wow, great.
Now, subsequently, lordship, given an opportunity of hearing, they have issued a vacancy notification, lordship. Kindly consider this aspect.
If you do not abide by my order that is passed on 16/2/2024, you will waste your time.
Miss Sinha, just wait.
No, after consideration of your
ঠিক
letter,
আছে.
I have heard.
has been issued.
I have heard.
No,
That's why this
what
hearing
this
opportunity has
terms
been
mean-
given.
It's not this lordship. They are supposed to make arguments on behalf of their. Please, sir, please.
No,
Please. They are
Okay,
supposed to
okay,
make
okay.
arguments and I'm supposed to counter.
You can't say
But
like that.
some provisions
I
of
have
law.
heard. I have heard.
I am referring
I have
to
taken your content.
only. My
It is
lord,
disputed. Kindly.
No, look,
in
look,
February,
no.
What they
No,
are
no,
saying,
no.
Lordship.
What you are going like that?
Yes.
Not
Their
necessary.
scenario also-
Not necessary before this court.
I have
I
just,
know the law. You know the law.
I have just
Ms.
made a
Sena
point.
also stating the fact that you
That-
must have submitted
Yes.
necessary application for reconstitution.
That's what I'm
You
saying.
have not done this.
No, no,
You
Lordship.
have filed an application
Yes.
in plain paper.
Yes.
Lordship,
That's
now,
what I'm saying.
And that's why you are saying that one hearing was taken
Lordship,
now.
Lordship, that is my mistake. Kindly come to page number 47, Lordship.
47 I have
That
seen.
is the acknowledgement, Lordship.
I have seen that. I have
Received
seen
that
that.
application.
Let them submit a report.
Yes,
Please take down.
I'm very sorry, Your Lordship. For
No, not necessary. You not necessary to raise your voice like that. I have taken your contention on the first instance. So what is the necessary?
I know that they have to make a case before Your Lordship, but the right law should be.
They are
placed.
the petitioners. They had.
But my bounden duty.
Yes,
Your Lordship,
I have taken your contention at the first time. At the first when you open your mouth. Okay. Full stop.
Lordship, the affidavit of service will be kept in record, Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Full stop. Petitioner along with his mother was running a partnership business of FPS under the license issued by the concerned subdivisional controller, issued by the Food and Supply Department concerned. Full stop. Mother of the petitioner, that is one of the partners. Expired during the continuance of the said partnership business. Full stop. The license issued in the name of partnership business was put an end. The petitioner filed an application for induction of one of his brother as a partner in the said business. Filed an application dated 22nd of May 2023. In pursuance of such application, one hearing notice was served upon the petitioner and other legal heirs of the deceased partner on 29th of April 2024. Full stop. It is the contention of the petitioner that hearing was conducted by the concerned authority.
Lordship, but the application made on 4th of March 2024, Lordship. That is in page number 48. Application made on 4th of March 2024. That is in page number 48, Lordship. That the counterpart has been given.
No, your application dated 22nd of May 2023.
Lordship, that is the representation.
That is the 46.
Page 46 is the representation, and my application made that is.
Where is the application?
Lordship, at page number 48, Lordship. That is the counterpart given from the.
Why you not place the application?
Lordship, I have the counterpart that the acknowledgement has been given.
I understand you have the counterpart. Where is the application?
Lordship,
why you not file the copy of the application?
Lordship, so
you have filed only the representation on 22nd of May 2020.
That the counterpart had have an annex, Lordship.
So this is not the application counterpart
that is the acknowledgement, the retrieve application from Mr. Azhar Hossain on instructions.
So where is the application?
Lordship, there is a signature. Lordship, so far that the
so
counterpart.
This is not the application. That is.
Yes, this is the counterpart, Lordship. That is the acknowledgement. That is the
page
acknowledgement.
46 is the application or
no?
not?
It's a representation. Page
so this is not the application.
Not the application.
So where is the copy of application?
Lordship, the counterpart has been given.
I have seen the counterpart.
Yes,
Lordship.
That is the acknowledgement. Lordship,
I want to know where is the application.
That is not with me, Lordship.
That is not with you.
That is the counterpart acknowledgement from the side of the receipt of the office of the subdivision. Says what says that the acknowledgement received from the application.
Why you not place the application?
That is not
Make an application and you do not place
if
the
someone
most vital
if someone has made an application, the counterpart will be given from their side.
Counterpart is not the
I will be-
determination. I want to see the application.
Yes, your lordship. I will
Then-
be more careful about to take a copy of the
Then a file application, thereafter I will pass the order.
But lordship, lordship, what is the meanings of this acknowledgement, lordship? That has been given from their side.
I just
Lordship, kindly consider my
No order can be passed on the basis of receipt, counterpart.
This acknowledgement has been given from them, lordship only.
You have placed the application with the department or not?
After this application, this counterpart has been issued, lordship.
Again, you are arguing any matter. So you place the document. You
Then
place
lordship,
the
kindly make it not today, lordship. I will come back tomorrow.
No, not
after vacation.
Yeah, no, not today, your lordship. Kindly pass an order.
I have to.
Kindly say.
I have to take the instruction whether I have a copy of the application or not, lordship.
Now the story
Kindly no story has been changed. Kindly.
Okay.
Kindly.
Just
Kindly. What is the meaning of the acknowledgement?
Okay, you place the document. I will pass the order.
Yes, kindly, your lordship.
What is the meaning of this acknowledgement? Is acknowledgement given from your side only?
Whatever. If you have a good case to make, you will
I
place
have a
all
good
proper
case to make.
documents.
Don't argue like that.
Okay, just heard.
Behave like a senior.
I have heard both of you.
No.
I'm not senior to you right now. I'm your strongest opposition at this point of time.
No. Absolutely.
Kindly,
What is
your
the meaning
lordship.
of the acknowledgement? Even we are filing a writ petition, we get an acknowledgement WPA number. It doesn't mean that I have not filed any application.
See the contents.
Yes, কি বললাম? না তার আগে বলেছি বলো। Prior to that. না তারও আগে বলো।
Lordship, can you mention that page number?
Just wait. কি বলেছি বলো?
That I am showing an acknowledgement.
Written application dated 22nd of May 2023. Full stop. Next part. It is the contention of the petitioner further contended that another application was filed by the petitioner which was received by the concerned authority on 4th of March.
Yes, your lordship.
4th of March 2024. Full stop. 24 for running the business
Lordship,
under
the acknowledgements concerned, it has been stated that
for the running the
in terms of
business
association of partners.
under partnership form. Full stop. In pursuance to such application, and a hearing notice was served upon the all legal layers of deceased partner on 29th of April 2024. It appears from the papers of the writ petition and annexures thereof that the application which was filed by the petitioner on 4th of March 2000, which was acknowledged by the concerned department on 4th of March 2024, and copies thereof were not placed with the writ petition. For better determination of this matter, the petitioner is directed to furnish the document, that is the copy of application which was received by the concerned department on 4th of March 2024. Further order will be passed after submission of that document. Let the matter appear within 1 week of vacation, ensuing summer vacation. Under the same heading. Next.
Yeah, in item number 26 and 24, lordship, liberty to file a fresh, lordship. I am to withdraw this application and liberty to file a fresh, lordship. 26 and 27, lordship. Liberty to I am placing for withdraw this application, lordship, and liberty to file a fresh, lordship.
Very good.
26.
Having heard the learned counsel for the petitioner, let the instant writ petition be with a liberty to the petitioner to sue afresh on the same self cause of action.
Yeah, that's why I'm withdrawing, and that liberty may be given to file a fresh.
Sue afresh on the basis of same cause of action.
Yes, your lordship.
Item number 26 and 27.
27, lordship.
The association will cannot maintain this.
No, when I will file a fresh, you will come with all the points.
Forget it.
You see, they are withdrawing.
They are withdrawing, not necessary.
I will file a fresh, you will come.
They are withdrawing, not necessary to mark.
Liberty to file a fresh, lordship.
28. 28, my lord. I am for
26,
the-
27, same order. Similar
28, I am
order.
For the petitioner lordship, this is the same as earlier matter lordship. Can you direct the
Same as earlier matter means
item number 18 lordship.
Acha.
item number 18.
There are 3
That is the
weeks.
direction to the state authority.
To file
File
the-
report within 3 weeks after vacation. Okay, okay.
That's the affidavit of service.
Affidavit of service file on behalf of the petitioner is taken on record. Similar direction. Extensive report in the form of affidavit within 3 weeks after vacation. Reply. Exception within 2 weeks thereafter. Liberty to sue appraise. Let the matter go out of the list. Liberty to sue appraise. Let the matter go out of the list. Yes. Same.
It's a 28.
This is 28.
28. There's a direction for filing of report in the form of affidavit, 3 weeks. Why, one question that I'm bound to ask myself, why let the matter be going out of list, your lordship? Kindly fix the date, we will submit and we will argue.
Okay, okay. So, similar order last week of June.
And one question again, your lordship, I'm disturbing. Why sue afresh? This is already there.
Sue appraise.
Yes, lordship, that's fallen from your lordship.
No, no, that is not the matter. Sue appraise in respect of item number 27 and
Oh, that is, they have
they are-
withdrawn.
they have withdrawn.
There was a slight confusion.
28.
Similar order. So item number 29.
29, I am appearing.
Also, I am for the
I am led
petitioner
by
lordship,
Mr.
the same
Sumant
direction.
for the state.
Give me your name. 29, similar direction, 3 weeks after vacation. Report in the form of affidavit, 3 weeks after vacation. Thereafter, after 2 weeks, reply exception. It would appear last week of June 2025. Next.
30, my lord, I am for the state response.
Similar matter. Similar order. Extensive affidavit in the form of extensive report in the form of affidavit. 3 weeks after vacation. Report exception within 2 weeks thereafter by the petitioner. Let it appear at the last week of June 2025 under the same heading.
Oh, 31.
30.
Huh?
Tell of 30.
Weekly hope 35.
31.
31.
Next.
31 one of the picture.
31.
What was a similar matter?
Mr. Charaji, similar direction.
Grateful, madam.
Extensive report in the form of affidavit within 3 weeks after vacation. Exception reply by the petitioner within 2 weeks thereafter. List the matter at the last week of June 2025 under the same heading.
Grateful, madam.
Submit the affidavit. Where is the affidavit?
Just say 5 minutes where the clerk is getting the brief. I'll just hand it over within 5 minutes. 5 minutes.
Then the matter will be taken up after 5 minutes. Why none? You are not ready.
Evidence of
Is
service.
just bringing the-
Evidence of service.
Is that
You have to place the report because my officer will go. Okay, okay.
Grateful, madam.
Call next matter.
I'm applying for this too.
Item number 32. Similar matter.
Similar.
You are for the state. File a extensive report in the form of affidavit within 3 weeks after vacation. Reply exception within 2 weeks thereafter.
Also, we are also filing a supplementary affidavit also. Serve a copy to the state justice.
In this.
Yes, sir.
Okay. Item number 32. Not correct. Item number 32. Supplementary affidavit file on behalf of the petitioner is also taken on record. affidavit of service supplementary দুটো পর আলাদা item number 32 yes
33, I appear on behalf of the petitioner.
okay
Now, because of my lord's kind interference, many things have come out, and my lord, they have filed a report in the form of an affidavit.
okay
Now, my lord, by today, my lord, I am serving my learned
Exception.
friend, my lord, an exception to the report. I have prepared, but it has gone for affirmation. My lord, I say, my lord, kindly take it any day after vacation, because
give me the report.
I will be giving a copy to my learned friend but in course of the day.
Very good.
But because of my lord's intervention, I say, my lord, with the greatest of respect, my lord, many things are surfaced out. There is I did not know this. I should be very candid. The system of allocation of marks, and this has been and there is a distribution as to how this has to be done. And I find that in a particular place where there is a provision for comparison, that comparison has not been followed.
You take this on
Yes, I have taken that. I have taken.
Okay. A report in the form of affidavit filed on behalf of the state respondent is taken on record. A report in the form of affidavit filed on behalf of the state respondent number 3, only 3. Respondent number 3 is taken on record. Copy has already been served. Copy has already been served upon the petitioner.
তোমার মতো এরকম একটা ভালো ঘুড়ি এবাকে দিও না। তোমার
Learned
এরকম
senior,
সুন্দর ঘুড়ি।
learned senior counsel appearing on behalf of the petitioner submit that a exception to the report has already been prepared and that has to be placed for further determination of this matter.
You know, kindly fix up a date. I appeal to my lords, which suits my lords. Any date which suits my lords under the same heading, so that my lord, I will not be taking more than my lord 10 minutes.
Then come on 17th, you are there.
I leave it to the court. It is the
You are
court's
there on
pleasure.
17th. 18th or 17th?
18th will be
18th.
better because I have many matters also before your lordship.
18th?
On the 18th. If that
I have
suits you,
nothing. I have no matters. Therefore, I can come whenever it suits my lords.
and it is always a pleasure arguing.
Yes. No, I actually accommodate both the parties so that
we know that.
I can
Lord,
hear it
cannot-
out.
I cannot express anything.
No.
Leave it on your lordship.
Let the matter appear in the list on 18th of June 2025 under the same heading. Full stop. The report stroke exception
18.
be filed after serving a copy to the same to the learned counsel for the state.
আজকে দিয়ে দেব।
না না ঠিক আছে।
34, my lord, I beg to appear for the
I am for the respondent, private respondent. I intend to bring the preliminary objection regarding maintainability of the writ petition. Admittedly, he is not a eligible candidate.
Yes.
Admittedly, he is not a eligible candidate.
He is eligible. He was found unsuccessful candidate.
May I place my case or my learned friend may?
I just want to point out one document. My lord, yesterday.
So what is the matter about?
My lord, matter about that I inspect the issuance of fair price. Issuance of fair price. Our inspection was conducted by the authority. At the time of application,
You applied for license.
I applied for license. Our inspection was conducted. I satisfied the requirement. It's my case because engineer, the spot inspection report is also prepared by an engineer, government engineer. I submitted to the authority without considering anything. Nothing has been declared. I got information that private respondent number, my lord, 8, purportedly they are issuing the license in his favor. I put an objection immediately. Then they sit tight over the matter. I filed a writ petition. So, my lord, yesterday night I received a notice from them. I mean, my lord, subject to correction, my client, where my lord purportedly they asked me to appear their office on 11 o'clock at 11 a.m. on 20 May 2025 positively for disposal of application and petition. Yesterday night I have received. Now, Lord, my case is that their primary objection which they have is that my godown and office
is above 400 square.
However, maybe you have submitted application, they have given you a call, so you appear there, let them appear there.
They didn't reflect the application of
I don't know what document he is showing. Take it to the.
They have
So it's not
already
part of
issued a
the
hearing notice. Let him appear before the authority.
Page 51, that is the objection I have submitted before the authority. If they are taking into consideration that application, then my lord.
You appear there, thereafter
Yeah,
I am keeping it pending. You appear there, thereafter the matter will appear.
My client will appear.
Okay. Affidavit in opposition filed on behalf of the petitioner is taken on record.
Affidavit of service.
Affidavit of service.
This is the first time.
Only one of the records, one of my submission that he has already been found ineligible.
Very well.
Because from this document, it appears that the bank, there was no money on that date of application from his document. Land has been given deed of gift in a notary. These are the 2 points. Both says registered deed of gift and money on the bank. Your lordship, kindly 2 minutes. I can show because I want to show that he is not eligible. Can what state is
also take note of that document. This is also filed.
No, these documents cannot be taken like that. You have to file a supplementary to that.
Grants me liberty, I can file it. Because
No, I am giving you I am taking the note of all the submissions, taking note of the submissions and relegate the matter before the authority, whether they have to deal the matter or not.
May I make one suggestion?
Your lordship, hear out this matter.
That is the merit. I am not hearing the merit.
My application got rejected. They replied me in the RTI.
No, that is not the issue altogether. They have called you, you satisfy their call, appear there, thereafter you can come here. Okay, ki bolo? Affidavit in opposition, affidavit of service filed on behalf of the petitioner is taken on record. Full stop. It is the contention of the petitioner, next para. It is the contention of the petitioner that he applied for license.
Just a minute. This is a communication by the subdivisional controller. This is not formal at the district level sub-selection committee. He made a representation. For that, he has been asked. Kindly record.
Let him appear.
Yes.
Okay.
Because his application has been possibly rejected. Kindly record it. This is not by the district level sub-selection committee.
He applied for license. License of
rejected the
FPS.
application, my lord, on
Full stop.
17th of March.
His application was considered, no, in terms of his application, the proposed shop come go down of the petitioner was inspected. However, the petitioner has raised some objection against private respondent. In spite of that, the private respondent was approved for the license. Full stop. It is the contention of the petitioner that the act and action of the authority concerned is arbitrary and illegal. Full stop. Learned counsel appearing on behalf of the private respondent submits that the petitioner is an ineligible candidate. Thus, the instant read application is not at all maintainable. Full stop.
On twofold grounds, twofold grounds, primary grounds is prime consideration. There is no bank account. It appears from on the date of application. On the date of application, it appears from his document. There was the 50,000 matter. And from his document, it further appears.
Learned counsel for
Deed of gift is the notary one.
The learned counsel for the private respondent further submits that the petitioner was not economically sound to have the license. And there are some other grounds for rejection of his candidature. Full stop. Learned counsel appearing. Learned counsel for the state respondent submits that the state respondent submits
the
that
application was already, he was declared ineligible by the district controller in all respect on 17th of March 2025.
Okay.
Is there any document?
No.
And subdivisional is issuing that letter.
Very well.
That I do not know because this has come from the bar. This is not part of the court's record. I am not making any comment on that. But the district controller rejection is on record.
The learned counsel, Mr. Dotto, appearing on behalf of the state respondent, submits that the present petitioner is an ineligible candidate in all respect, and the learned concerned authority has already rejected the candidature of the applicant of the petitioner on 17th of March 2025. 25. So he further submits that decision has already been taken by the concerned authority.
Finding
So
the most
the writ petition is not at all maintainable. Learned counsel appearing on behalf of the petitioner objected to the contention of the respondents and submits that in terms of his representation and objection placed before the subdivisional controller concerned, a hearing notice was served upon the petitioner asking him to appear personally on 20th of May 2025. He placed the copy of the hearing notice dated to 14th of May 2025. Having heard the learned counsel for the parties, it appears that the concerned subdivisional controller food and supply, Midnapur Sodor, had already issued a hearing notice upon the application of the petitioner, which contain the merits and similar facts of the writ petition. Accordingly, I restrain myself from passing any order in that matter. Let the instant writ petition be appear after 1 week after vacation under the same heading. Full stop. The petitioner is directed to appear before the concerned authority in terms of the hearing notice.
Great.
But point of maintainability left open.
Point of maintainability raised by the respondents are kept open.
And Lordship has not gone into the merits of the matter.
Not gone into the merit. Not gone into the merit of this matter. I have not passed any order.
Only adjourn.
Only taken your submissions on that point.
Great.
Subject matter.
What is item number 1? Call it.
Number 1.
Yes, my lord. The application for recalling, if your lordship kindly take it for once, it is made under order 9 book 13. And my lord, order 9, first of all, I will submit later on. My lord, order 9 rule 13, and kindly see what is there order 9 rule 13. Your lordship knows. I know that your lordship has the vast experience and your lordship has seen the periphery of the order 9 rule 13. May I read, madam? Setting aside decree ex parte. If any 13, setting aside decree ex parte against defendant. In any case in which a decree is passed ex parte against a defendant, he may apply to the court by which the decree was passed for an order to set it aside. And if he satisfied the court that the summons was not duly served, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree circumstances. That is a clear provision. I will submit later on. Madam, your lordship has seen that in paragraph 5, your lordship kindly see that your lordship.
Paragraph 5 of Can 1 of 2024 you are referring?
My lord?
Can 1.
Can 1.
Yes.
But your lordship kindly take my affidavit.
Your affidavit.
Paragraph 7, my lord. Page 4.
Paragraph 7, page 4.
Yes, sir. With reference to paragraph 4 of the said application, I deny and dispute the statement made therein, save except what the matter record. I said that the procedure adopted for mentioning the matter before the honorable court was that notice should be served upon the respondents before mentioning, and upon following the said procedure, the matter was mentioned and thereafter duly appeared for days together, but two learned advocates appearing for the respondent did not appear, and as such, there was no alternative open to the Honorable Court but to pass the order on merit, even if ex parte, and at this juncture, the respondent cannot take advantage of their own failure to appear before His Lordship. And my Lord, Your Lordship, kindly see paragraph 9, this page 4, paragraph 9. This paragraph, with reference to paragraph 6 of the said application, I deny and dispute the statement and allegation made therein, save and except what are the matters of record. I say, in paragraph 6, paragraph 5, the respondent stated, but a copy of the said and said, you have seen that is given to the other advocate who is in order to meet. I state that this statement is not correct, and no copy of the affidavit in opposition was ever served on to the petitioner or his learned advocate, and on no point of time, Srimati Sushmita De Basu, advocate, was engaged by the petitioner or appeared for the petitioner. The statement is false and made with an ulterior motive to deprive the petitioner. I say that respondent should prove the statement made by them, failing which the Honorable Court will take appropriate steps against for the false statements.
আপনার এই একটা অ্যাফিডেভিটের কপি চেয়েছিলাম এখন এই
Yes.
না না ঠিক আছে দেওয়ার দরকার নেই আমি কোর্ট থেকে তুলে নেবো দেওয়ার দরকার নেই।
আমি তো দিয়েছি আপনাদেরকে আমরা আগে বলে দিই আপনি আমাকে এমন কিছু নেই যে দেবো না নাও মাই লর্ড ইউর লর্ডশিপ ক্যান সি the status of the party. The petitioner before your lordship is a driver casual and he has already retired. He made an application before your lordship and they are the mighty estate. They do not like to appear before your lordship. What they are saying that it is, we have not seen it, we have not got it, we have submitted whatever. All is wrong. The estate, they can go, they are mighty estate, they are defending mighty estate, they can go before the Supreme Court. But the poor driver who has already retired, who was casual, he has no power to go before division bench also. He has no money also. This is the status of the party. Your lordship has to consider what is the status of the parties. Now, my lord, your lordship kindly come to paragraph. This is the most important paragraph. Your lordship kindly page 3, paragraph 5.
Page 3.
Page 3.
Of your affidavit in opposition. Yes.
With reference to paragraph 1 of the said application, I deny and dispute the statement and allegation made therein 7 except for the matters of record. I say that this application filed by the respondents under Order 9, Rule 13 of the Code of Civil Procedure for recalling order dated 1/8/2024, passed by His Lordship the Honorable Justice Shubhendu Samantu in the impugned proceeding is not maintainable and deserve to be dismissed because in a writ proceeding application made categorically is not maintainable. I further say that recalling application is also not maintainable. But your lordship, they have said that the Supreme Court says yes, it is maintainable. Your lordship, can you see that I have taken out that judgment, my lord? I am giving to lordship. Ushan Singh and others, my lord, versus the state of Punjab. Ushan Singh and others versus the state of Punjab. They relied on 1996 true Supreme Court cases, 2005.
2005 হবে না এর পেজটা কত বললেন
2005
2005 SCC 2005.
Have you placed it?
Yes, no, I am giving to your lordship.
Okay, okay.
Because this copy is not to lordship because it will not tally because they have given, my lord.
EIR হতে পারতো এটা এআইআর দিলেন না এসসিসি
না এসএসসি
এসসিসি 2005 পাতা একটা ভলুমে
দেখেন দেখে নিন দেখেন
205
205
2005 বললেন এসসিসি তে ভলুমে 2000 কখনোই হতে পারে
But your lordship, they have given your lordship a copy. If this is a tally, I am giving your lordship the another copy. My lord. If
They have
you are-
already
I am
given
relying
me a
upon-
copy.
But
No,
I
the
have
state
the-
respondent has not placed anything like that. They have already placed one MAT 1671, 2011 2 SCC, 2010 9 SCC, 2012 4 SCC.
Yes.
They
Yes,
have already placed these.
Yes. And my lord, your lordship,
one EIR.
Your lordship, kindly they have given the EIR. Yeah, that's
EIR.
why they have given the EIR.
AIR copy.
EIR 1996 Supreme Court 1092.
Okay.
Puram Singh versus State of Punjab.
Yes.
AIR 1992 Supreme Court 1096. Para 9 and 10.
Yes.
Power of the Writ Court.
Power of the Writ.
It does not depend on Civil Procedure Code. Power of the Writ Court.
Nineteen 1996 Supreme Court.
Yes, yes.
1092.
1092.
Paragraph
So,
7.
You want to refer this paragraph?
7.
Paragraph 7.
But this
And
is
then on the
this
tally
is
which-
SCC paragraph may not the match.
Similar or you can read it. I can find
Well,
it.
7 is the when the High Court exercise extraordinary jurisdiction.
Yes, got it.
Yes, you will continue. Well, I'm get to your lordship. When the High Court exercise extraordinary jurisdiction under the Article 226 of the Constitution, it aims at securing a very speedy and efficacious remedy to a person whose legal or procedural right has been infringed. If all the elaborate and technical rules laid down in the code are to be applied to writ proceeding, the very object of the purpose is likely to be defeated. Kindly note this. According to us, in view of the conflicting opinion expressed by the different courts, Parliament by the aforesaid amending act introduced the explanation saying that in section 141 of the code, the expression proceeding does not include any proceeding under Article 26 of the Constitution and statutory recognize the views expressed by some of the courts that writ proceeding under Article 226 of the Constitution shall not be deemed to be a proceeding within the meaning of section 141 of the code. After the introduction of the explanation to section 141 of the code, it can be said that when section 141 provides that the procedure prescribed in the code in regard to the suit shall be followed as far as it can be made applicable in all proceeding in any court of civil jurisdiction, it shall not include a proceeding under Article 226 of the Constitution. In this background, according to us, it cannot be held that the provisions contained in Order 22 of the Code are applicable per se to writ proceeding. If even before the introduction of the explanation to section 141, this court in the case of Babu Bhai versus Nandalal had said that in the words as far as it can be made applicable occurring in section 141 of the code made it clear that in applying the various provisions of the code to the proceeding other than those of a suit, the court has to take into consideration the nature of those proceedings and the relief sought for after introduction of the explanation. The writ proceeding have to be excluded from the expression proceeding and occurring under section 141 of the code. If, because of the explanation, proceeding under Article 226 of the Constitution has been excluded, there is no question of making applicable, applicable the procedure of code as far as it can be made applicable into such proceeding. The procedure prescribed in respect of suit in the code, if are made applicable to the writ proceeding, then in many cases it may frustrate the exercise of extraordinary powers of the High Court under Article 226 and 27 of the Constitution. See, then first the Supreme Court say that there is a procedure which can be delayed the procedure. That's why this is said. Now, if paragraph 10. Paragraph 10. On a plain reading,
yes, it is in paragraph
on a
8.
Paragraph 10. On a plain reading, section 141 of the code provides that the procedure provided in the said code in regard to suit shall be followed as far as it can be made applicable in all proceedings. In other words, it is open to make the procedure provided in the said code in regard to suits applicable to any other proceeding in any court of civil jurisdiction. The explanation which was added is more or less in the nature of proviso, saying that the expression proceeding shall not include any proceeding under Article 226 of the Constitution. The necessary corollary thereof shall be that it shall be open to make applicable the procedure provided in the code to any proceeding in any court of civil jurisdiction, except to proceeding under Article 226 of the Constitution. Once the proceeding under Article 226 of the Constitution has been excluded from the expression proceeding occurring in section 141 of the code by the explanation, how on the basis of section 141 the code of the code any procedure provided in the code can be made applicable to a procedure under Article 226 of the Constitution? So if you could asking a question to in this background, how merely on basis of Rule 32 of the provisions of the code shall be applicable to proceeding? Because the article they said the Calcutta High Court has said adopted Article Rule 32. Supreme Court is how it will be read. Supreme Court's question is this. Now, my lord, well, apart from this, that section 141 of the code, even in respect of other proceeding, contemplates that the procedure provided in the code in regard to suit shall be followed as far as it can be made applicable. Rule 32 of the Rule does not specifically make provisions of code applicable to petition under Article 226 and 227 of the Constitution. That is the High Court. They said the Calcutta High Court has adopted their Supreme Court said it is not applicable like that. There is no saying that it should be taken into consideration. It simply says that the matters for which no provision has been made by these rules, the provision of the court shall apply mutatis mutandis insofar as they are not inconsistent with those rules. In case of the Rokeabi versus Ismail Khan, in view of Rule 39 of the writ proceeding, rule as framed by the Karnataka High Court, making the provision of Code of Civil Procedure applicable to writ proceeding and writ appeals, it was held that the provision of the code were applicable to writ proceeding and writ appeals. 11. We have not, this is the very important paragraph, and this is last line is very important. we have not been able to appreciate the anxiety on the part of the defined courts in judgment referred to above to apply the provisions of the code to writ proceeding on the basis of section 141 of the code. When the Constitution has vested extraordinary power in the High Court under Article 226 and 227 to issue any order, writ or direction, and the power of superintendence over all courts and tribunals throughout the territories in relation to which the High Court is exercising jurisdiction. The procedure for exercising such power and jurisdiction have to be tested and found in Article 226 and 227 itself. No useful purpose will be served by limiting the power of the High Court by procedural provision prescribed in the code. Of course, on many questions, the provision.
This is the vital.
You are not giving me.
Yes, you
it
proceed. Yes.
You give me to say so.
Okay,
You proceed. But I'm talking the last two words and last two points. The High Court is expected to adopt procedure which can be held to be not only reasonable but also expeditious. You are not continue. He's saying, now, my lord, you will to kindly see the court. The court has provided when an ex parte decree has been passed. And you will when the ex parte decree has been passed, then what is the procedure before as provided in the Code of Civil Procedure? Well, there are three procedures. One, 96. 91. Any ex parte decree has been passed. One, Order 8 Rule 10.
Yes.
And Order 9 Rule 13. Three procedures. What Supreme Court said, you adopt the procedure which should be expeditious. Here, if as I said, they have taken the good procedure, Order 9 Rule 13. But what is happening? Why they have taken? They have not filed the appeal. The thing is that if appeal would have been prepared, then the time would have been limited. But when your lordship has a first experience that when Order 9 to 13 or Order 9 to 10, any application is being filed, it is years after years the suit is continued. And in this case, if it is this order has been recalled, then I will not be able to finish this matter in my life. This will not be because no hearing is taking place. What can be done? What can be done? Because it is the procedure. Because the Supreme Court says expeditious. Why they should not take when there are three procedures? Expeditious is for filing an appeal. You should why you will file 9 Rule 13 or Order 8 Rule 10? Because you have to file any application which should be expeditious. If appeal would have filed, then it has been going to hard it out. Now
may I take leave for 5 minutes? Well, other matter is going on there. Just I would come back immediately.
If they do, if these three procedures, they choose which can be lengthy one. And your lordship, by adopting this Supreme Court judgment, you have laid down the law. Whether there should be an appeal or should be a recalling order, which should be prevail. Because as per Supreme Court, 141, Supreme Court said that which is expeditious. And by the code, there are three procedures. Your lordship, the appeal is the expeditious. But
I understand.
Now, my lord, if that is so, your lordship will have to say, and they have taken the Order 9 to 13. But now I am coming to that. When 141 is a bar, 141 is a bar, they have taken Order 9 to 13. Even if Calcutta High Court had adopted Writ Rule 32, that cannot be. That Supreme Court said that you cannot be, which is barred by the legislature. You cannot say write Order 9 to 13. And Order 9 to 13 is bad in law. In writing Order 9 to 13, it will be Order 8 to 10. If said. Because why I am saying, it is the High Court, is the court of record. Whatever you like, what you going to say. You are saying order 1930. You are saying that we have not appeared, even if the two advocates are there. If we are saying we are submitted, then whatever you like to say against a person who is a driver, who is already a casual driver, retired. Now, my lord, if any, your lordship knows, any law cannot, my lord, override the act. Any statute cannot override. But I am giving the judgment. Yes. বলছি বলে দেবো 2003 4 SCC 524
আমার হাওয়াটা আসছে এটা বন্ধ করে দিয়েছিলেন না
well paragraph 11 I'll not waste your time, your lordship, kindly for paragraph 11.
Paragraph
11 page 530. Here what may I say what happened? Here a person was disabled when he was in force.
You are in?
He was in force.
Okay, 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 okay.
And his leg was amputated. And thereafter, he was said, the department says, you are not able to work with it. You are not able to work because your leg has amputated and such and such. Then, my lord, then he was getting the pension. He was getting the pension as per CCS pension rule. Now, he filed the case before the High Court. Then, no, he said, I am not a retired person. I should be in the service. Then the question arises, there is disabled person at your lordship. It is there. But the person, but it is there. There, Supreme Court says, no, when the disabled person acts, section, my lord, and your lordship, paragraph 11, in this context, your lordship kindly read. We have to notice, then you can see. One more aspect, in relation to the applicant getting invalidity pension as per Rule 38 of the CCS rules, pension rule, the Act is a special legislation dealing with person with disabilities and to provide equal opportunities, protection of rights and full participation to them. It being a special enactment doctrine such and such would apply. Hence, Rule 38 of the Central Services Rule cannot override Section 47. Rule cannot override. What I want to say, my lord, any rule, if there is any section, cannot override the. And further, Section 72 of the also supports the case of the appellant who is treated as such and such. The rule cannot override the Act.
So your submission is the rule made by the High Court. High Court administration cannot override the section on 141
not
of
only that, not only that, but your lordship kindly see the Supreme Court categorically said you have to add up. When you said two lines, you kindly see two lines again, my lord.
Yes.
Okay. The High Court is expected to adopt a procedure which can be held to be not only reasonable but also expeditious. Then, your lordship, I have said that your lordship, there are three procedures. In challenging ex parte order, there are three procedures laid down in the court. They can file an appeal, order 8 rule 10, they can order 9 rule 13. It is the expeditious. Your lordship had to help that. Your lordship has the vast experience. That appeal is the most
expeditious procedure to determine the issue.
And not only that, we have writing more than it is the applicant and order than it is not maintainable itself. It is not maintainable, and the contention made in the application that you must have seen. I can repeat it because they are the mighty estate. I cannot go to that. They have not say any sorry to the lordship. Then they have made such and such a statement before your lordship. And my lord, if it is allowed, my lord, it will be approved.
Okay. That's all?
That's all.
Reply.
Reply.
Mr. Sen, any reply?
My lord, reply. Yeah, my lord, so far that, my lord, the contention raised by my learned friend with regard to that, my lord, the maintainability of my
Order 9 rule
application.
30. Yes.
Order 9 rule 13, maintainability of my application.
Yes.
Now, my lord, application which has been made before your lordship is that, first of all, my lord, in our high court, there is no, my lord, the specific, my lord, the convention that I have to, my lord, specifically mention that the application is made under this section or under this rule. The nature of the application, my lord, it appears from the prayer itself. What I pray before your lordship.
Yes.
Nature of the application, it depends upon the prayer. So for the can application specifically, when in connection with any pending matter. If it is a substitution, then it also, my lord, appears from the nature of the application. If it is for any subsequent interim order, it would appear from the nature of the prayer of the application. If it appears that I want to recall an order passed by your lordship in that very particular matter, then that would also, my lord, would appear from the nature of my relief claims therein.
Yes.
Here, my lord, the nature of the application that I claim the relief is that recalling of that order of your lordship and for fresh hearing. Because I could not appear on that day. Now, the question is this, whether the writ court has power to consider here the said application or the writ court has no power. Once the order passed by the writ court, that is the final. Or the still court has power that, yes, to hear the application, if it appears that substantial material is there, then it can be recalled. The source of power.
Yes.
The question is ultimately the source of power, where from the power emanates. Source of power.
Okay.
Now, my learned friend says that the source of power, there is, first of all, there is no source of power. The court has no power. The writ court has no power to recall its order, which was passed because of, my lord, expertise, because of one of the party could not present himself on that day or could not be presented by his advocate. No power. Now, my humble submission is that despite being the fact that section 141 of CPC, in proviso, it is stated that that particular code is not applicable to writ court. But two things are there. This question came up before the Honorable Supreme Court. That is, my lord, the 1986 judgment. There the question was regarding, so far the facts are concerned, so far I recollect, with regard to substitution. But in any event, the principal issue before the Supreme Court was that, first of all, whether substitution that is provided under the civil procedure code, my lord knows that, under, my lord, order 22, substitution, abatement, order 22, and even order 22, rule 10 also provides that suppose, my lord, the transfer of ownership.
Yes.
During pendency of a suit, and my lord knows that I personally made several applications time to time when I, my lord, several matters I appear in suit court. Suppose during pendency of partition suit or that type of, my lord, suit, the title suit, the property transferred from one party to the suit to other. Then the transferee of that immovable property, he can come up and file an application
Yes.
for also substitution,
For
but
addition
not
of
because of
parties.
death,
Yes.
because of transfer of title. That provision is also there. Now, Civil Procedural Code is a complete code. Now, whether any of the provision is applicable. Now, the Supreme Court in 1986 Supreme Court, that my lord, what I referred before your lordship, that particular paragraph 9 and 10 I referred before
Yes.
your lordship. That Supreme Court in that particular judgment initially said, yes, that is true, that the Civil Procedure Code is not applicable in that total. But the Supreme Court said that that does not mean that the Writ Code is powerless. It has jurisdiction, and it appears from the Article 226 itself, extraordinary power of the Writ Code. Extraordinary power, this expression, my lord, it carries heavy weight.
Yes.
And this is the difference from suit code to Writ Code. We have never heard when my lord is sitting in my lord's suit court, that my lord is using my lord's extraordinary power. But the my lord himself, when your lordship sit in Writ Court, my lord can use your lordship extraordinary jurisdiction, extraordinary power.
Yes.
And the Supreme Court says, yes, the court is not powerless, irrespective of the fact that the CPC is not applicable. Still, the Writ Court has its extraordinary power to bail out the litigant from this type of situation. So, the Writ Court, it is not a fact, the Writ Court is powerless. Apart from that, the Supreme Court also considered that every high court can also they frame their own rules. I think either in para 9 or in para 10, the Supreme Court said high court can frame its own rule.
Yes.
Now, our high court has framed our high court's own 226 rules. And in that rule, my lord, I have shown your lordship that we have adopted the Civil Procedure Code, and here it is said that mutatis mutandis Civil Procedure Code provisions are applicable in Writ Code, and that has not been challenged. So our High Court's Writ rules, it is there. Supreme Court says that the court is not powerless, so far the Writ Code. So my humble submission that whether that Civil Procedure Code is applicable or not, whether my application can be stated that order line rule 13 or not, my prayer is that I want to recall my lords that order, and that prayer, that application is maintainable and court has power.
Yes.
Number one. Number two, I agree with my learned friend's contention that two options are there. I could have preferred an appeal, or my lord, I make an application before the same court itself. I can. Now, this choice of forum, kindly, my lord knows much very well than me. Choice of forum is with me. Whether I file an appeal before my lord's order, or whether I shall prefer an application, I can take out an application before your lordship. That is, my lord, the choice of forum. Now, choice of forum, my lord, two types.
Yes.
Choice of forum, two types. If it is, my lord, lordship, kindly consider one thing in the, my lord, in civil court also. If it is territorial jurisdiction, if it is pecuniary jurisdiction, or if it is neither pecuniary nor territorial restricted, but the same jurisdiction in two forums. Kindly consider. If it is territorial jurisdiction, if it is barred, then I cannot say I have choice of forum.
If both the forum has the same
If two forum having same jurisdiction and same power, alternative. So my choice is rest upon the litigant. So I have choice, I choose this forum. Before your lordship, I file this.
Okay.
So, Mala, this is all lordship.
Okay.
And so for merit, Mala, I have already submitted on the. I do not want to iterate anything.
No, not necessary.
Fine.
get.
Please take down. Argument on behalf of the parties concluded in respect of Can 1 of 2024. Made CAB.
I'm grateful to Lordship.
Yes.
With the Lordship kindly play.
Call the next matter.
I'm for the state lordship.
No?
Similar matter, Lordship. I appeal for the petition.
Item number 35.
Due to service model.
আলি নিয়েছে সিমিলার ম্যাটার গোটা 10 অর্ডার হয়েছে, এটাও সেম অর্ডার হবে, ঠিক আছে? আলির কাছে আছে, নিয়ে নেবে। আলি নিয়েছে আলির কাছে নিয়ে। Some similar order has been passed in this matter today. So in the all matters, direction is upon the state authority to submit an extensive report in the form of affidavit within 3 weeks after vacation. Reply exception by the petitioner within 2 weeks thereafter. Let the matter appear in the list under the same heading in the last week of June 2025.
My lord, all the other matters are on the second week of June, my lord. If it could have been listed together.
No, the same order is there, all third week. Yes. Next.
36, my lord, it is the same matter, my lord. Similar order could be passed.
Affidavit of service filed on behalf of the petitioner is taken on record. Similar direction. Affidavit similar direction. 3 weeks after vacation. Affidavit extensive report in the form of affidavit. Reply exception by the petitioner within 2 weeks thereafter. Appear in under the same heading in the last week of June 2025. Next.
In item number 37, Lordship, I beg to appear on behalf of the petitioner, Lordship.
Yes.
Lordship, the matter was taken up in earlier occasion and subsequently, Lordship, that state was non-represented, and then after we made a letter to the state for the upcoming Lordship dates, and there is an interim order. There is no scope of interim order. Your Lordship was not passed any interim order, but Lordship, we have on that occasion, Lordship, we have stated that during the pendency of the writ application, there are some developments are there, Lordship.
So called notice was served.
Yes, your Lordship, and I have made a supplementary evidence and duly served upon the state advocate, Lordship.
Who is appearing for the state advocates?
Lordship, Sonal Sinha.
Have you served?
Yes, your lordship, I have served. Lordship, can you peruse the affidavit of service, lordship?
Lordship, she's in another court. I'm kindly praying for not today.
Lordship, let the matter be taken up at the second half, lordship.
Today? No, second half I have some fixed matters.
Lordship. Then not today, lordship, because he have to answer, lordship. In earlier occasion also, lordship was directed.
Supplementary affidavit filed on behalf of the petitioner taken on record. Affidavit of service filed on behalf of the petitioner is also taken on record. Let the matter appear tomorrow under the same heading.
Grateful to your lordship.
My lord, because of item 38, my lord, I appear for the state.
Another notice or lordship, usual court, my learned friend is there, lordship, he will inform.
38.
My lord, I appear for the state.
Who is for the petitioner?
But I appear for the petitioner.
What is the matter? Okay.
My lord, I understand my lord has passed some similar orders. My lord only
Yes.
keeps the issue of maintainability open. That is my
Okay,
only prayer.
very good.
Because it is again that issue of detagging with matters have been argued.
I understand. We are on that matter.
Yes, yes.
Uh,
One of the
Affidavit
matters
of
that we
service
kept on
filed on
the-
behalf of the petitioner is taken on record. Similar direction. Report in the form of affidavit. Extensive report in the form of affidavit within 3 weeks after vacation. Petitioner to file exception reply against the report within 2 weeks thereafter. Let the matter appear in the list in the last week of June 2025. Point of maintainability as raised by the learned counsel for the respondent kept open.
I'm so grateful, my lord.
Okay.
ফাইলের মধ্যে দিব
Item
Uh, I come with a very innocuous prayer, Lordship. Before Lordship started this today's list, Lordship, there is certain urgency in this matter, Lordship. I seeking leave to file and come back
Which matter?
tomorrow. Lordship, I am seeking leave to file and come back tomorrow after service, Lordship. Similar matter, Lordship, tomorrow, today morning, Lordship, has granted a leave, Lordship. I am only similarly circumstances in my matter, Lordship, that someone is awarded with a license, Lordship, despite of having any go down, Lordship. I have the every qualification to get the license, Lordship. Subsequently, the private respondent are awarded with a go down, Lordship. Similar matter, Lordship, placed tomorrow, Lordship. I will be similarly circumstances, Lordship. Leave may be granted. I will
Tomorrow-
serve. One person has taken leave, Lordship, has granted. By tomorrow, Lordship, the matter will be taken up. I am also similarly circumstances, Lordship.
How similarly circumstances?
Because,
Which
Lordship, the
matter?
points are similar, Lordship, that there is one vacancy notification has been issued and I applied
The
in that.
matters is relating to vacancy notification, I
Yes, your
understand.
Lordship.
So
Leave may be
how-
granted.
leave may be granted, no issue, but can you serve upon them? within that-
I will serve, Lordship. In the meantime, I will serve, Lordship. Grateful to your Lordship. Tomorrow. Tomorrow একটা দিয়েছো? I will come. Grateful.
Call the matters.
Easily assigned matter. Item number 2. I for the respondent.
I'm for the petition. In the last occasion, Mr. Chatterjee has submitted
Yes.
the brochure where several conditions has been laid down by the respondent authority for allocation of the dealership. In the said situation, I must draw your lordship to the lease deed at page number 87, my lord.
Now, what is the issue in the writ petition? Why you challenge?
It's there is the allotment was given to the private respondent, debarring me from from giving the LOI, where the criteria for the land in question, where the dealership will be given, is not matching at all as per the brochure.
Land offered by the private respondent.
My lord.
What land he has offered? She has offered, Sangeeta Maji.
My lord, just kindly come to page 42, my lord. My lord, please.
Yes.
That well, kindly come to the advertisement first. দেখেছিস কি এটা? না না দাদা এক মিনিট Kindly come to page 23 once. I just recollect the submission made by me on the last occasion.
Yes.
Item number page 23, item number 114, 1114, where the stipulation is that the land offered by the candidate should be the length and frontage and depth should be 30 square meter.
Yes.
Now the land offered by the private respondents herein, in whose name the letter of intent was issued, that is not fulfill the criteria as mentioned in the advertisement. There in the brochure, there is a provision, kindly come to page 38 once, and the page 67. Page 67, withdrawal of letter of intent. There is a provision for withdrawal of letter of intent if the declaration is false. And
how can you say that the declaration is false?
I attach the deed which is submitted by the private respondent.
Where the deed is?
Kindly see page 86. 86, page 86. And the schedule of the property is at page 93. Kindly see the district Bakura, PS Chatna, jail number 31, Mouja Parasia, Kotian number 40/3, plot number 901, total area 0.32 acres, classification out of which 0.22 acres of land. Kindly see now the parted and bounded portion in the north 85 feet, in the south 72 feet, in the west 122 6 feet. What has happened? 30 square meter equal to 98.42 feet. And kindly see the measurement of north and south. And then kindly come to this is the deed of lease which is submitted by the private respondent, which was executed on 5th April 2018, page 87. And this is a lessor is the Mamata Chatterjee. 4 lessors are there: Mamata Chatterjee, Joydeep Chatterjee, Srimati Mou Mukherjee, and Srimati Piu Mukherjee, stating themselves the owner of the property. Kindly see the records of right, which is at page 129 and 130. Kindly see the last tag number 494 or 495, where the measurement of the area 0.11 acres of land in the name of Mamata Chatterjee, one of the lesser. And kindly turn to the next page, 496, 0.11, that is totaling 0.22. 0.22 land belonging to Joydeep Mukherjee and Mamata Chatterjee, not that Piu Mukherjee. The name is mentioned as a lesser. How the right of the Piu Mukherjee and the Srimati Mou Mukherjee has been created? Records of right says otherwise.
These are the entirely disputed question of title and everything.
The authority
How can
respond.
this
No,
court can
there is a eligibility criteria. Those who
I
have applied
understand
for
there are
the
some eligible
they have
criteria.
to submit a deed which is will be fulfill the criteria as mentioned in the advertisement, and there is a provision for inspection by the respondent authority to that effect, which is mentioned
They have
in the brochure.
inspected.
They have inspected. Nothing has been done according to us. Letter of intent is issued. How the letter of intent issued in favor of the private respondent, if the inspection is correct? And kindly see the subsequent deed. They submitted a subsequent deed, which is at page 111, which was executed on 16th day of August 2023. Now the part name Gautam Maji and Pintu Mukherjee and Bijoy Maji, being a lesser, leased out this land in the favor of Srimati Songita Maji. And kindly the schedule of the land 116. Schedule of the land A property, that is the entirety of the same property as the earlier deed which is submitted, which was executed in the year 2018. Where PS Chatna Mouja Parasia LR Khotian number 40/3. Now kindly Schedule B property. Now they are sticking of the Schedule B property. Chatna jail number 39 Mouja and LR Khotian number change 571. First of all, they offered a land where LR Khotian number 40/3 in the 2018 deed. Now they offered a land where LR Khotian number 571. Now kindly see the stipulation.
Khotian, LR Khotians are in respect of different persons, different Khotian.
Khotian cannot be changed. It is mentioned in the brochure.
No,
Kindly
Khotian, the lessers may have the separate Khotian in LR.
If the applicant offers same land by rectifying the deed, whatever.
Land and Khotian is totally separate. Land is a specific land. Khotian is in respect of separate persons.
But in the brochure, it is mentioned. Kindly page 70. Consider page 70 once. That is their guideline.
So you are disputing the title.
Disputing, not the disputing title. I am disputing the letter of intent issued in favor of the private respondent on the basis of the deed.
So deed, the justification of deed and titles thereof, that cannot be determined by this writ court.
Well, let
You
them,
know
let
the
there be a
matter.
direction
I
for
can
further-
relegate the matter to determine your matter, your objections, your representations.
Objection and inspection.
Representations, everything.
And
they can
inspection to
you
that effect.
determine your representations. Have you determined this representation?
In my affidavit, my lord, I have disclosed the deeds.
No, these matters are all titles like that.
My
The
representation.
question of facts from my learned
Yes.
submission is very clear. He is seeking fact finding. This is not a fact finding court.
No, I
The
cannot
face of
enter into
it-
title.
Well, I know this is not the fact-finding code, but there is a guideline upon the brochure
There are guidelines.
that Khotian number cannot be changed if the applicant offers similar land. Here they offered similar land, but Khotian number, how the Khotian
Look,
is
that
changed?
is the all separate issue or understanding is that. In LRR, in RSROR, there are single Khotian in respect of single plot. In LRROR, there may be a multiple persons holding the same plot, but there are separate Khotians. If the co-sharers of plot of land transfer the right in favor of the licensee or in favor of the applicant, there may be separate Khotians.
And
No
there is
dispute
a
there is.
and there is a
But
lack
I
of,
am not entering into that matter right now.
but there is a lack of the measurement, depth, and frontage. Admittedly,
Whether you have you made any
yes, yes,
representation
yes, I
to that
attach
effect?
page
Where
one,
is your representation?
page 136, page 133. Kindly see. Without considering my representative, they issued letter of intent in favor of the private respondent. Where when the inspection has been done, no notice was given to us.
Why will my learned friend submit the notice?
Okay, you have submitted a application on 23rd of March.
Yes.
2024.
Yes.
Before the learned, before the Chief General Manager, Retail.
And the head of regional
head of
office,
regional office.
Durgapur Retail Regional.
Only this one-page representation.
And
That is the frontage and
subsequently page 134.
Mr. Chatterjee, what can be done in this matter? I cannot go into the matter as raised.
Let there be a inspection, investigation to that
No
effect.
inspection, no investigation.
But in terms of the deed,
they would deal with
the-
your representation. Okay, I relegate the matter to the authority.
Now, if your lordship hears me for 2 minutes.
Yes.
The advertisement clearly stipulates that I am entitled to offer a land. Either I have ownership or by a lease. But I obtain a lease from third parties, registered lease, I offer the land.
No, who is for the private respondent? You are now. He is the.
I am for corporation.
You are corporation. You are for the private respondent. So private respondent has issued a deed. But forward a deed.
We have caused inspection of the deeds. Pursuant to inspection of the deeds, we have issued letter of authority. But the deeds, my learned friend has suppressed those deeds in his writ petition. I have disclosed those deeds by which the title flows.
I have
upon
not
the private-
suppressed anything.
Private respondent, my lord. Based on that, my lord, the quantum of the land that has been offered comes to a calculation, my lord, by way of two deed of lease, my lord. In respect of one deed, the private respondent has offered 22 decimal. In respect of the other deed, the private respondent has offered 9.5 decimal. And computing to these two, a fresh lease was been executed for 24 years, which is 31.5 decimal.
Okay. There are another lease deed.
But I have acquired my right by way of a lease deed. If your lordship kindly sees the advertisement once, page 20, my lord. The brochure, my lord, at page 42. Two documents I will show. Perhaps this is not a case where this honorable court will entertain, my lord.
Yes.
But page 42, clause 6, land.
Yes.
Land applicable to all categories. The applicants will be classified into 3 groups as mentioned below based on the land offered or land not offered by them in application form. Group 1. Applicants having suitable piece of land in the advertised location, either by way of ownership or long-term deeds for a period of 19 years, 11 months or as advertised by you. So I hold a land which having lease of more than 19 years. So I qualify in this category, my lord. But in support thereof, my lord, I have disclosed before the private respondent, my lord, has disclosed before us, my lord, a deed of lease, which is at page 87 of the writ petition.
Okay.
But this is a deed of lease dated 5th of April 2018. But this deed of lease is in respect of 30 years, mal. If your lordship comes to page 91, page 90, my lord, this is for 30 years. The second last paragraph, my lord. I'm not placing the documents in detail, my lord. Perhaps is not required for your lordship, my lord, at this juncture to go into the merits of the matter, my lord. Now, if your lordship now comes to page 91, but there is a sublet clause, page 91, clause 3.
Yes.
But this lease was acquired by Gautam Maji and Pintu Maji from one Mamta Chatterjee and Joydeep Chatterjee in respect of 22 decimals. Now, if your lordship kindly takes up my affidavit once, page 19. But this is another deed of gift in respect of 9.5 decimal. Mala, the schedule is at page 29 of the deed of gift.
In favor of Bijoy Maji.
And they have executed a lease deed in my favor. So I acquired it. But that is at page 29. But 9.5 decimal. So Mala, the earlier lease was in respect of 22 decimal. This lease deed is in respect of 9.5 decimal. So both the lease deed constitute 31.5 decimal. Now, if your lordship comes to page 111 of the writ petition once, now the picture will be very clear. For page 111, if your lordship comes to of the writ petition, my lord. But now Gautam Maji, Pintu Mukherjee, Bijay Maji, they execute a deed of lease in my favor in respect of the entire 31.5 decimal. So I acquire my right and interest over the land over 31.5 decimal, which is the offered plot of land. A advertisement shows that I have to have either own land or leased out land for more than 19 years. So that is been fulfilled. If your lordship now comes to the schedule ones, but page 123, I take your lordship directly to the major information of the deed.
Yes.
But land details, if your lordship sees the third column, fourth column, if your lordship sees 31.5 decimal. So my criteria gets fulfilled. I was a group one candidate. The private respondent was a group one candidate. Offered a land. We caused inspection of the land. Land found to be in order, and letter of appointment was being granted. But if your lordship now takes up page 35 once, my learned friend was harping on the point from day one that he was also a group one candidate who had offered his land. If your lordship comes to page 35, if your lordship comes to serial number 9, group of the applicant on the basis of land being offered. Admittedly, he is a group 2 candidate. So his aspersion that I was a group 1 candidate, I have been bypassed and the private respondent has been awarded, that is a wrong aspersion being cast, man. And if your lordship once takes up my affidavit, I have clearly and categorically stated, my lord. If your lordship comes to page 3 of my affidavit, page 4, my lord. There is a tabular statement which I have prepared, my lord. I was the private respondent was group 1 and the petitioner is group 2. If your lordship now comes to the next page, page 5.
Yes.
But if your lordship comes to the bottom of it, the first lease deed which I had showed your lordship, those two lease deeds constitute 31.5 decimal, which is at the bottom of page 5, my lord. I have indicated, my lord, the page of the lease deed, two lease deed by which my lessor had acquired the right in favor of his and he leased out the property in my favor. So that is for 24 years. But that covers 19 years and above. But the third last line from the bottom.
So lease deed number 4993.
Which I have disclosed in my affidavit, my lord. If your lordship now takes the third last line, here it is for 24 years. But the advertising brochure says it has to be 19 years and above. But the total area is 31.5 decimal and period has been indicated. But now, if your lordship comes to the next page.
Yes.
I have described in detail the deeds. If lordship takes the middle of the page, deed of sale, by which my lessors have acquired the interest, my lord, that is indicated in the tabular statement bottom, 9.5 decimal. And now if your lordship comes to the next page, page 7, by way of another deed of lease, the lessors acquired their rights. The tabular statement, last column shows 22 decimal. So, my lord, there is no discrepancy at all. At the face of it, it is evident that I am a lawful, the private respondent was a lawful occupant, produced the valid deeds, it was being inspected upon, and letter of appointment was being granted. If your lordship now comes to page 9 once, subparagraph J.
Yes.
The application of the respondent number 8 for retail outlet dealership was selected by the respondent authority on the grounds that respondent number 8 fulfilled the specific land criteria. The land offered by respondent number 8 is with a frontage of 35 meters and depth of 30 meters, situated 1 kilometer from Johehira High School along the Saltora to Jhantipari Road in the district of Bakura. The suitability of the land was assessed using land evaluation such and such by retail outlet site evaluation parameter. My learned friend's allegation is it was not being inspected. So there is a committee of the respondent which has done the inspection of the land, which is the land equivalent coefficient LEC by retail outlet site evaluation parameters, and the respondent authority selected the land as it made the requirements stipulated in the advertisement published in 18/7/2023. Thus, the LOI was been issued. Now, in terms thereof, I was been granted, the private respondent was been granted the appointment letter, my lord, and that is what is being challenged. But my specific contention of the petitioner was I am not holding a title. The private respondent is not holding a title in respect of 9.5 decimal, which deed we have disclosed in the affidavit.
Okay.
But lordship is now well aware that constitutional courts, my lord, in these tender matters, my lord, until unless sheer perversity is being shown, my lord, will not entertain, my lord. Well, I've got the judgments, my lord. If your lordship desires, my lord, I'll place NG projects. Consider NG projects and Agmatem. And your lordship, recent judgment. Okay. But if I may hand over to 2024 volume 10 SCC 273.
Bansidhar.
Bansidhar, my lord. I'll just indicate, my lord, the relevant paragraphs. If your lordship comes to paragraph 31 of the judgment, my lord, where Starling was taken into consideration while exercising the power, your lordship got it? While exercising the power of judicial review in respect of contracts entered into on behalf of the state, the court is concerned primarily as to whether there has been any infirmity in the decision-making process. In this connection, reference has been made to Chief such and such. The purpose of judicial review is to ensure that the individual receives fair treatment and not to ensure that the authority, after according fair treatment, reaches on a matter which it is authorized or enjoined by law to decide for itself, a conclusion which is correct in the eye of law. If you, by way of judicial review, the court cannot examine the details of the terms of the contract which has been entered into by the public bodies or by the state. Courts have inherent limitation on the scope of any of such inquiry, but at the same time, as was said by House of Lords such and such, the courts can certainly examine whether the decision-making process was reasonable, rational, not arbitrary, and violative of such and such. And the next para, Tata Cellular was taken into consideration, my lord. The principle which was being laid down, the modern trend points to judicial restraint in administrative action. The court does not sit as a court of appeal, but merely reviews the manner in which the decision was being made. The court does not have the expertise to correct the administrative decision. If a review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise which is followable. The terms of invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in realm of a contract. Normally speaking, the decision to accept the tender or award the contract is reached by the process of negotiation through several tiers. More often than that, such decisions are qualitatively by the experts.
Yes.
But the next paragraph which I intend to place reliance is paragraph 34, my lord.
Jagdish
Dana, lordship is well aware, my lord. I am not troubling your lordship by placing that, my lord. The next judgment, my lord, 2022, volume 5. Agma 10, my lord, 362. The relevant paragraphs, my lord, are this has dealt with Galaxy's Galaxy Transport. If your lordship comes to paragraph 25 of the judgment, my lord, paragraph 24, my lord. The scope of judicial review in contractual matters and particularly in relation to the process of interpretation of tender documents has been the subject matter of decision in various decisions of this court. We need not multiply the authorities on the subject as suffice. It would refer to the 3 judges bench of this court in Galaxy such and such, wherein amongst other the said decision in AFCON has also been considered, and this court has disapproved the interference by High Court in the interpretation of the tender inviting authority of the eligibility term relating to the category of vehicles required to be held by the bidders in the tender floated for supply of such and such. This court referred to various decisions on the subject and stated the legal principle as follows. In a series of judgment, this court has held that the authority that authors the tender is the best person to understand and appreciate its requirement, and thus its interpretation should not be second guessed by a court in judicial review proceedings. Now, the next paragraph which I intend to rely on, if your lordship further comes down, my lord, wherein Jagdish has again been considered, my lord. The paragraph 22 has been set out. If the decision relating to award of contract is bona fide and is in public interest, courts will not, have your lordship got it?
Yes.
In exercise of power of judicial review, interfere, even if the procedural abbreviation or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest or to decide contractual disputes. The tenderer or the contractor with a grievance can always seek damages in a civil court. What has just fallen from your lordship, my lord. Attempts by unsuccessful bidders with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehills of some technical procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. Such interference, either interim or final, may hold up public works for years or delay relief and succumb to thousands and millions, and many increase the project's cost manifold. Therefore, court, before interfering in tender or contractual matters in exercise of judicial review, should pose itself the following questions: whether the process adopted or decision made by the authority is mala fide or intended to favor someone, whether the procedure adopted or decision is so arbitrary in nature that the court can say the decision is such that no responsible authority acting reasonably and in accordance with relevant law could have reached. But if your lordship now further comes down to the bottom, my lord, considering Monte Carlo, but there is a bold portion if your lordship sees.
Yes.
But where a decision is taken that is manifestly in consonance with the language of the tender, the document or subserves the purpose for which the tender is floated, the court should follow the principles of restraint. Technical evaluation or comparison by the court would be impermissible. This is what my learned friend is inviting your lordship to do so. If your lordship next takes paragraph 26, the above mentioned statement of law make it amply clear that the author of the tender is taken to be the best person to understand and appreciate its requirement, and if its interpretation is manifestly in consonance with the language of the tender documents or subserving the purchase of the tender, the court would prefer to keep restraint. Further to that, the technical evaluation or comparison by the court is impermissible, and even if the interpretation given to the tender document by the person inviting offers is not as such acceptable to the constitutional court, that by itself would not be a reason for interfering and interpretation given. Applying the aforesaid principles to the case at hand, we clearly of the view that the impugned order cannot be sustained. But if your lordship next comes to paragraph 30, my lord, AFCON has been laid down, taken into consideration, my lord. But the next paragraph is paragraph 33.
Yes.
Viewed from any angle, interference by the High Court in this matter does not appear justified, particularly when no case of mala fide or bias is alleged. Every decision of the administrative authority which may not appear plausible to the court cannot for that reason alone be called arbitrary or whimsical. The High Court in the present matter be obviously proceeded with an assumption that the view has been taken by it in acceptance of the case of the writ petitioner was required to be substituted in place of the views of the tender inviting authority. That has been an error of law and cannot sustain itself in view of the consistent binding decisions of this court, including the three judges bench as in Galaxy. The High Court, while supporting its process of reasoning, has referred to such principles which, with respect, we find entirely inapposite and beyond the periphery of the question involved in the present case. As noticed in such matter of tenders, contracts, the process of interpretation of terms and conditions is essentially left to the author of the tender document, and the occasion for interference by the court would arise only if the questioned decision fails on salutary tests laid down and settled by this court. Inconsistent decisions, namely irrationality, unreasonably, or bias or propriety. The last decision, my lord, is your lordship's recent one, my lord. So I had the privilege to appear before your lordship, my lord. Unreported judgment. But this is the last decision lordship has been pleased to, my lord, taking into consideration of all these judgments, my lord, lordship has been pleased to hold, my lord, that constitutional course, my lord, in tender inviting authorities in terms of the law laid down by the Honorable Apex Court, my lord, judicial restraint is for practice is followed, my lord.
Yes.
This is not one such case, my lord, where your lordship will exercise your lordship's constitutional powers, my lord. But it's really a fact-finding dispute, my lord. the petitioner has alleged, and I have tried to demonstrate from my affidavit, my lord, that I am holding a valid right, the private respondent, and accordingly it was made. So these are my submissions.
Yes.
Let's seek your lordship's leave, my lord.
Yes. Reply. For the private.
She is for private respondent.
Yes.
My lord, I have given the deeds as which has already been demonstrated by my learned friend.
Have you used the affidavit?
Is it
Yes.
just
You have
stated as how my ownership has been, and accordingly we have submitted as per the application. Thereafter, I have been chosen as the selected day and the bidder, and the letter of intent was issued in my favor. My lord, the only thing is that at this point of time, I have applied to the Gram Panchayat for the NOC, which they have not issued owing to the pendency of this writ petition, which is annex. I have given letter which is appearing at page 21 and 22 of my affidavit in opposition.
Okay. That's all? Yes.
Well, may I give reply?
Yes.
Kindly come to page 86 of the writ petition. How they have filed their affidavit in opposition, describing the deed and the lessors. Page 86 is the deed executed on 5th day of April 2018. It is lesser, kindly see page 87. Mamata Chatterjee, Joydeep Chattopadhyay, Mou Mukherjee and Piu Mukherjee. 4 persons are declared themselves as a lesser, and they list out their property in favor of Gautam Maji and Pintu Mukherjee. Now kindly come to the affidavit filed by the Hindustan Petroleum Corporation Limited at page 8. Page 8 of the affidavit in opposition filed by the respondent number 224. Middle paragraph. Page 8.
Yes.
Middle paragraph starts with Mou Mukherjee and Piu Mukherjee. But it has got it. Had signed and executed the lease deed as a confirming party as being the legal heirs of the Krishnadas Chatterjee. Yeah. Had they executed the deed by confirming party, declaring themselves? They're declaring themselves as a lesser owner of the property. How the inspection has been done? Affidavit shown by the authority. The appointing authority stated that they have signed the agreement, a deed as confirming party, and deed is before your lordships.
That is the lease deed, page 88.
Page 88. 86 starts from page 86.
Page 88 is the deed executed.
Deed of lease.
Deed of lease.
And kindly see page 87.
No, executed by Mamata Chatterjee.
Mamata Chatterjee, Joydeep Chattopadhyay, Srimati Mou Mukherjee and Piu Mukherjee, declaring themselves as lessor. And kindly see the lesser, kindly see page 91's middle paragraph, stated that by way of such inheritance, the lesser inherited the property led by Kalidas Krishnadas Chatterjee and Krishnadas Chattopadhyay in accordance with the Hindu Succession Act 1956 and thus become absolute joint owner in the possession of the same. And till now, the lesser have been owing or positioning the land mentioned in the schedule below, along with the other land exclusive and lawful owner.
So what is your contention?
Contention is that kindly see the
So
affidavit. They
Krishnadas
stated
Chattopadhyay has expired.
expired.
So after that, the Mou and the, you say Mou and Pew are the legal heirs.
Kindly see the Khotian records of right. I am stated that page 129. The land only belonged to in favor of Mamata in the name of Mamata Chatterjee and Joydev Chatterjee. Page 121. 0.11 decibel of land belongs to last Dag 495. Mamata Chatterjee.
Swami Krishnadas Chatterjee.
Yes, and kindly see the next. Joydeep Chatterjee. 0.11. Total measurement of land 0.22. How the name of Pew Mukherjee has come? They don't have the Khotian even.
So you say Pew Mukherjee is not a party there. That means the pure title you have challenged. That the Pew is not the wife, not the.
Kindly say their kindly see their averment. They executed the deed as
Pew and
confirming
Mou being
party.
the Pew and Mou being the
They
daughters.
are not the owner. Owner is Mamata Chatterjee and Joydeep Chatterjee by way of inheritance.
Very well. I understand.
I kindly see that their affidavit. They said that being a confirming party, they executed, but the deed says otherwise. And none of the deed submitted by the private respondent stipulates that they have the actual measurement which is required in terms of the advertisement: 30 feet, 30 square meter depth and 30 and length. Kindly see the schedule of the schedule of the deed. Nothing has been mentioned. I have categorically stated that 30 square meter equal to 98.42 feet, where it is mentioned in the schedule that they complied the provision of.
Fact is that two deeds are there.
Now they have come another deed, 3 deeds. Now they are saying 3 deeds.
First 2 deeds, thereafter a single deed.
Yes,
containing 31.5 decibels.
5 decibels.
So 31.5 decibel means 30 meter into 30 meter. That is sufficient.
That is the entire land, not the length and depth.
So length and depth, they have said
the land offering land should be the depth and length of 30 square meter
whether
each.
you have anything to contradict the inspection of the authority.
But
that
no opportunity,
no
nothing.
such-
We don't nothing. After issuance of letter of intent and after filing my representation before the authority, nothing has been done. Now they are going to give going to issue the appointment letter in favor of the private respondent.
Okay, I understand. That's all.
I kindly see page 71. This is the page 70. What are the list of non-rectifiable deficiencies in the application? One of the criteria is change in Khosra and Khotian survey. It's city at the offered land, which I have stated before your lordships that Khotian Pew and Mou has no Khotian at all because they are not the owner. According to the deed, they falsely stated that we are for the owners, we are the lesser. Now we leased out the property in that name of another. Records of rights says otherwise. And kindly see point number P, point number 23P. Changes in Khotian, it's the offered land. That provision which is not rectifiable. And the judgment referred by my learned friend on behalf of the respondent, where there is a perversity, court can interfere. Where there is a perversity apparent on the face of the record, there is a clear violation, clear discrepancy in the declaration, and he did not meet the requirement as mentioned in the advertisement. The Honorable Court cannot make them silent over the matter after perusing the all records. Perversity is there, absolutely. And kindly see the page 20, clause number 23. If the same land offered in multiple application of the same location, all application will be rejected.
Same land offered?
Same land offered in multiple applications of the same location. All such applications will be rejected.
So whether he have offered same land in...
First of all, they submitted to 2018 lease. Their a scheduled property. Can you see the schedule?
Where is the application of the applicant? That is the private respondent.
In the opposition, they have stated. Page 16 of the opposition they have annexed. Can you see page 17? Plot number, kindly see the Khotian Eller Khotian number 43/3 first deed in concern with the first deed. Now the second deed 571, then 558. Page 17.
I want to see the application filed by the private respondent.
Right, kindly see page 16 once. Page 16 of the affidavit in opposition filed by the
page 16.
16. 16.
No, page 16.
Opposition by the respondent number 224.
Respondent number 224.
224.
Yes.
Kindly see page 17 once. The relevant portion where the plot number 1. Kindly look to Khotian number 40/3. The first deed 2018. Subsequently, the Khotian number changed 571. Then in respect of the last deed 558. Is it permissible? According to brochure, there is no change of Khotian. Khotian number
all the Khotians. They have mentioned all the Khotians.
All the Khotians. That cannot be.
Why not?
Why not?
That cannot be because I applied for the in respect of the on the basis of the one land.
They have not changed the Khotian. Changing of Khotian is not permitted.
But the first deed, in the first deed, the lesser,
they may permitted to file separate deeds. Separate Khotians may be there. This is the whether they have changed the Khotian, that would be looked into.
Alan, in total, there are 3 deeds. First is the one that
is admitted, but in the first deed,
by which the
those who have known
lessees over here.
The only question is that whether where is the title of Pew and
Mo Mukherjee.
It was not mentioned in the record of right. How they have transferred their right. This is the only question here.
Alan, they give it to Gautam Majhi and Pintu Mukherjee. Gautam Majhi, Pintu Mukherjee gives it to me.
I understand.
By way of a deed of lease, and thereafter there is another gift deed which has been annexed with the.
Kindly see Khotian number, absolute Khotian number is 495 according to page 129 of the writ petition. Khotian number is 495, 496. Appropriate Khotian number, not 40/3. On the basis of the strength of the first deed which was executed in the year 2018, subsequent two deeds are executed. If the first deed declaration is false,
There's another deed which is at page 111 of the writ petition, by which I have been given the right. I am the lessee over here. If my lord could see page 123 of the writ petition, my lord. Page 123, ma'am.
Okay. That's all?
Yes.
देखो.
May I take leave for 5 minutes?
Yes.
My junior is there.
Hindustan Petroleum Corporation Limited, within bracket, respondent authority, bracket close, published an advertisement for appointment of retail outlet dealership in the location situated within 2 kilometers of Jorehira, Jorehira, Jorehira High School on Saltoda to Jhanti Pahari, Jhanti Pahari, Jhanti Pahari, Jhanti Pahari Road in the district of Bankura under SC category. And the nature of dealership was regular. Full stop. Petitioner, comma, private respondent number 8 and other persons applied for the said dealership. HPCL had selected private respondent number 8 and issued appointment letter in favor of private respondent number 8 for the said retail outlet dealership. Full stop.
It's a LOI, not appointment letter. Yes.
Letter of intent.
Letter of intent or appointment?
No. Letter of intent has been issued.
Only intent was issued. Letter of intent was issued in favor of letter of appointment, letter of intent code, LOI. The issuance of LOI in favor of respondent number 8 was challenged by the by the petitioner in this writ petition. The grounds for challenge is that the private respondent number 8 has offered a land which is defective in title. Moreover, the area of the land specifically, the dimensions required for the said dealership, that is 31 into 13 to 30 meters in frontage and depth area. Of the said offer land was not available for the private respondent. It is the firm contention of the petitioners that in spite of such land being offered by the private respondent, the having disputed title, the concerned authority, without following the procedure established in the brochure, has issued LOI in favor of the private respondent without making thorough inspection. Full stop. Learned counsel for the
It will be thorough evaluation, land evaluation.
inspection and land evaluation for inspection, thorough inspection and land evaluation. Full stop. Learned counsel for the petitioner has placed the copy of deeds of lease in favor of the private respondent and submits that the persons who have executed the deed of lease in favor of the persons from whom the present private respondents had got the lease had no title over the said plot of land. He submits that the learned counsel for the petitioner also placed the present record of right, which contain the name of the owners, recorded owners of the plot of land, and argued that the persons, namely Mo Chatterjee and Q Chatterjee, had no right title interest over the land, but though they have transferred their alleged right of the land in favor of who is the persons?
Sangita Maji, the private.
No.
Sorry.
Gautam Maji and
Pintu
Mukherjee, who thereafter transferred their right to lease in favor of the private respondent. Full stop. It has also been contended by the learned counsel for the petitioner that none of the lease deeds has mentioned that particular area of the land having frontage and depth as required in the brochure stroke advertisement. Full stop. Mr. Chatterjee, learned counsel, appearing on behalf of the respondent number 224, file affidavit in opposition against the writ petition and contended that a deed of lease being deed number 00856/2018 Mamata Chatterjee, Joydeep Chatterjee, Mo Mukherjee, and Pew Mukherjee transferred their 22 decimal of land in favor of Gautam Maji and Pintu Mukherjee. Is it? Vide one deed of sale being deed number 02127 stroke 2023 deed of sale dated deed of sale by number 02127 stroke 2022 not 23 22 Devdas Mukherjee, Arun Mukherjee, Amya Prasad Mukherjee, Borun Mukherjee, Prashanto Mukherjee, Kamna Mukherjee, page 6 আছে Sharup Mukherjee transferred their right in respect of 9.5 decimal in favor of Bijoy Maji and Pintu Mukherjee. Thereafter, Vide lease deed number 4993 stroke 2023 such Gautam Maji, Pintu Mukherjee and Bijoy Maji transfer 31.515 decimal of land in favor of private respondent number 8. It is further contention of the respondent authority that respondent number 8 has fulfilled the specified land criteria. Full stop. The land offered by respondent number 8 having a frontage of 35 meters and depth of 30 meters, which is situated 1 kilometer from Jorahira High School along the Saltoda Jhanti Pahadi Road within bracket State Highway 8 Jhanti Pahadi Road under the district of Bankura. The suitability of the land offered by private respondent number 8 was assessed by the equivalent coefficient, land equivalent coefficient, and the other parameters of the land was properly inspected and evaluated by the committee itself. After thorough deliberation, Mr. Chatterjee further submits that after thorough deliberation, it appears that land offered by the private respondent is suitable for construction of retail outlet, thus LOI was issued. Full stop. Next para. Private respondent number 8 also used affidavit in opposition against the writ petition, wherein it submits that the LOI was issued in favor of the private respondent, but due to the pendency of the instant writ petition, Gram Panchayat Pradhan had not issued NOC for running the petrol pump business. It is further contention of the private respondent that he has fulfilled all the criteria as laid down in the advertisement as well as in the brochure. The respondent authority, after careful consideration of the documents placed by the private respondent, has issued the LOI. Having heard the learned counsel for the parties, it initially appears to me that the dispute as raised by the private dispute and the objection as raised by the petitioner in the instant writ petition regarding the correctness of title of the private respondent in the land offered by her for construction of retail outlet. Full stop. The petitioner has demonstrated that some persons having no title over the land has transferred their right in favor of the leisure of the private respondent. Full stop. It further appears that it is further challenge of the petitioner that the concerned committee of the private of the respondent authority has not clearly or properly inspected the land offered by private respondent. Full stop. The affidavit in opposition of private respondent number of respondent authority unequivocally stated that the authority concerned has offered LOI, has issued LOI in favor of the private respondent after successfully and deliberately making inspection and evaluation of the land offered by the private respondent. Full stop. Matters, next para. The matters regarding challenge of respondent authority in selection of a candidate through a tender procedure time and again has appeared before this court as well as before Honorable Supreme Court. There are several decisions of Honorable Supreme Court that which are the matters to be dealt with by the High Court in those matters. Amongst them, the respondent authority has placed decision of Bangshidhar Construction Private Limited versus Bharat Coking Coal Limited and others reported in 2024, 10 SCC 273. Also placed two koro Agmatel India Private Limited versus Resources Telecom and others within bracket 2022 5 SCC 362. Full stop. In Bangshidhar Construction Private Limited, the Honorable Supreme Court after considering earlier decisions of Honorable Supreme Court in Sterling Computers Limited versus MN Publications Limited, as well as Tata Cellular versus Union of India and Jagdish Mandal versus State of Odisha. Has come to an opinion that paragraph 36 that would go. In Agmatel India Private Limited, here. In Agmatel India Private Limited, the Honorable Supreme Court also, after detailed discussion of its earlier observations, in Galaxy Transport Agencies, and Galaxy Transport Agencies versus Galaxy Transport, whatever, Galaxy Transport Agencies and capital code and Monte Carlo Limited versus NTPC, has held that paragraph 26 for the federal court. This court, following the observation of Honorable Supreme Court in Gopal Noskar versus Hindustan Petroleum Corporation Limited and others, within bracket WPA 4082 of 2025, has also observed that the decision of the respondent authority in selecting a candidate under tender cannot be called in question always in a writ jurisdiction of a high court unless and until patent illegality or manifest arbitrariness is proved. Full stop. Next paragraph. In the light of the discussion made in above regarding the observation of Honorable Supreme Court in different citations, it appears to me that the present petitioner has challenged the decision of the respondent authority on the ground that the view adopted by the respondent authority regarding the title of the private respondent in the offer land is not the same as reflected in the brochure itself. Full stop. The authority who floated the tender is the best person to interpret the meaning and purport of the tender document. Full stop. It has been observed by the Honorable Apex Court that court would prefer to keep restraint in those matters where the tender document has been clarified by the respondent authority. Full stop. In the present case, the respondent authority, by using affidavit in opposition, has clarified or shown before this court that they have categorically inspected the documents placed by the private respondent, and it appears to them that she is the suitable candidate. Full stop. The petitioner may have placed some document which according to him justifiable to challenge the title of the private respondent over the land in question, land offered by the private respondent, but the same disputed question of fact or the title cannot be interfered by this writ court. Moreover, I am of a clear view that the title as challenged by the petitioner in the instant writ petition appears to me not so hers or illegal or imperative so to shocks the conscience of this court. Under the above observation, I am of view that the decision of the concerned authority for selecting the private respondent appears to me not so arbitrary to interfere with. Under the above observation, the instant writ petition appears to me not so meritorious to interfere. Accordingly, the instant writ petition is disposed of.
Kindly record,
Grateful, madam.
kindly record that in the application, what the Kotiam number the private respondent has placed and what the Kotiam number in page number 129 has been annexed, it's the ROR, is totally different. Kindly record the same. What my lord's team speed, I should accept that.
Look, if I go into the title or Kotian like that, that would be otherwise.
If the HPCL or the respondent authority states in the affidavit that they are the confirming party, it is the
Look,
prime
one
office view
person
that-
has expired. I know. If I go to the merit of title, I can answer your question. You know the answer also. One person has expired. The record of right was not made in favor of the heirs of the other person. The heirs has made the deed.
in the evaluation process or in the tender advertisement, there must be Khotian in the name of the person who is giving the lease. Who is giving the lease? Here,
that is the pure title question. I cannot.
Person has not given.
My lord, with regard to the NOC,
in
the
the
Gram
meantime,
Panchayats are not issuing the NOC, my lord.
Okay.
Just one line, my lord.
I am praying, kindly cancel the letter of intent, my lord. Stay the letter of
Yes,
intent in
yes.
the meantime, so that we can approach before the appropriate authority. Either everything will be infructuous.
Disposed of. The concerned authority is directed to issue concerned Gram Panchayat is directed to issue NOC as
Yes.
prayed for in favor of the
Private respondent number 8.
private respondent number 8 according to the law.
Yes.
Full stop.
Hello, kindly record my submission and reject the same.
What?
Stay of the letter of intent, my lord. In the meantime,
Learned counsel appearing on behalf of the petitioner submits for an order of stay of the instant order passed by this court. Having heard the learned counsel for the petitioner and considering the circumstances, I find no merit to pass an order of stay of the instant order. Accordingly, the order of stay as prayed for by the learned counsel for the petitioner is refused at this stage.
My lord, I think it should have been Mo Mukherjee and P.U. Mukherjee. It has gone down as P.U. Chatterjee or Mo Chatterjee. Just Mukherjee.
Okay.
Grateful, my lord. Mukherjee. Chatterjee hobe na?
Yes. Next.
For the appellate petition.
আপনি স্যার আমার গুরু, আপনি আসেন হাজার। Before going to the records, should I take 1 minute, 2 minutes for your lordship's perusals? This matter relates to challenge an order passed by the appeal court against the order of rejection passed by the court below.
Yes.
Thereafter, this matter was heard by your lordship
Paper book quick.
on
What is the paper book? In it.
আস্তে আস্তে take it easy, take it easy. Paper book আছে পাওয়া যাবে।
Yes, you proceed.
Lordship. Now, this matter was heard by your lordship in respect of interim order which has been granted earlier, whether that interim order can be extended in respect of the appellant or not. This is one of the issue before lordship. Ultimately, your lordship to some extent extend the interim order for a day.
I know the matter, you just come to the fact.
My lord, just before my lord coming the paper books, only I am before making my submissions, I am asking before lordship only for 1 or 2 minutes, not more than that. Thereafter, my lord, due to passage of time, the interim order was, my lord, not been my lord updates or extended, and no application for extension of interim order was come before lordships from the side of the appellant on the previous day when the matter was taken up. Now, question comes whether in absence of any interim order, application for extension of interim order, whether your lordship can extend the interim order on the side of the appellant, my lord. This point was argued before lordship. Your lordship desire was no, in absence of any applications, normally this court should not extend the interim order. Better you come up any applications for extension of interim order. And accordingly, in terms of your lordship suggestions, my learned friend filed an applications for extension of interim order, which has already been, my lord, expired long ago. In continuations of the interim order, my learned friend filed an application to restore the interim order passed by your lordship in earlier occasion. This is the, my lord, crack of the matter as on date. So for the
fact is that I have already made my submission.
Well,
Main appeal.
I'm coming because as
There is 2 applications. There is the date fixed for his submission as well as my application for interim order. Both.
Now,
look, I have heard you as an appellant.
Appellant, my submission has been made.
Your submission has been made. He has started submission already in the appeal. In the appeal. So now thereafter the matter was gone to this court, other court, regarding without the determination of this matter, the change of determination like that. Now it appears before this court again. So
as that is assigned before your lordship, matter has came before your lordship.
I understand. So I have to hear out the entire appeal.
Entire appeal, and when the matter has came, the date was fixed by your lordship. Last date was 21st of the previous. I have already applied for the before your lordship on 11th, but the matter came on 25th. So the interim order has been expired in between there. I have mentioned that on 25th of this matter. On that very day, your lordship has directed me. You should have to file another application for interim order.
Very well. Let me hear it out the appeal. I will pass the any order if necessary. Proceed with the appeal.
My learned friend is appellant. I am for the opposite party here.
Yes, you start. I have heard appellant. I have already detailed note is there.
Correct, lordship. Just
then you proceed.
Lordship.
Not required to delay the matter.
No, I need not to because I'm getting my
long pending matters is there. Yes. No,
the other side.
Yes, other side is supposed to argue on that matter. Only reply by the other side.
Only 5.
My senior, my lord, I cannot.
Let him argue for 5 minutes. Every
antagonize.
day we are
No, I shall conclude it and dispose of it today itself. No issue. I have already taken it on the mind. what can be done, what cannot be done.
Or
That is the
judgment-
only, the
judgment-
argument has to be concluded.
Judgment may be delivered tomorrow also.
Either judgment delivered on court, either or it would be taken on CAB.
That is up to you.
Yes.
That is up to you.
No, this is a parted matter, parted second appeal. I have heard the appellant. This is, he is the respondent. I have also heard the respondent considerably.
Also harder. So you
Yes.
don't give reply for 5 minutes.
So what you want now?
Let him complete just 5 minutes. You also can.
So what time you will require?
Some time, my lord. Let my land senior approach your lordship because my lord,
You take time. I know him.
my lord, my lord, we are learning. I am learning from my senior, my lord. I did.
I know.
My lord, we are learning from my
Very
senior.
well. This matter first, thereafter your matter.
Lordship. So kind of lordship. We are waiting, my lord. Just.
Yes, please wait.
Sir,
No, first these matters be concluded, thereafter I will take up your.
Is aware that I had filed an application for praying for an interim order. Your desire was to hear out the application itself.
Yes.
But because the new vacancy the notification has come, but I have challenged my termination. Now, if this is
Let me
proceeded
finish
with-
this matter. Here.
let's see, my lord, lordship knows, my lord, there is protracted
Item number 4, 5, and 6.
my lord, there is protracted history of litigation after the death of father, mother applied. My lord, the one son and sisters are favoring mother. And the other sons, my lord, from the very beginning, my lord, opposing mother. Now he is in the habit of opposing, my lord. Now he is still opposing the, my lord, so far this allotment is concerned, distributorship is concerned, against the brother who was staying with his father and mother and maintaining a cordial relation with the sister. Now, my lord, what happened? My lord, after a protracted litigation, lordship at a point of time, my lord, in the kindly see 30876 of 2024 for a moment, my lord. For a moment. My second writ application. My second writ application, lordship kindly come to 44. The judgment which was written by the Honorable Justice Ananda Kumar Mukherjee, my lord, as his lordship then was sitting with Honorable Justice Subroto Talukdar. My lord, here, after 2-3 rounds of litigation, my lord, the Honorable Court was kind enough to, my lord, reject the contention of the Abdur Rauf, the client of my learned senior, and directed the authority to allot this particular business, my lord, in the name of mother, the wife of the deceased. Because so far the spouse are concerned, no objection, consent letter is not needed. The department is also, my lord, aware of the fact. In spite of knowing all this fact, they are favoring Abdur Rauf from the very beginning. That is the nexus in between, my lord, the private party and the state authority. My lord, I have referred my judgment of Shalini Shetty, lordship, my lord, kindly recall. Now, lordship, what happened as to why I am making this submission, my lord, the department favors from the very beginning. My lord, this Abdul Rauf, lordship, kindly come to page 44 of this writ application. Just I am reading, my lord, to recapitulate the whole thing, my lord. Page 44, annexure P9, in the last part of the, my lord, the order, the D.K. Singh, Subdivisional Controller, Food and Supplies, Malda, has written, so objection of Abdur Rauf cannot be taken into consideration so far mother allotment is concerned. However, as Abdur Rauf is also seriously interested, my lord, my person is seriously interested, how it is to be ascertained? Eligibility provisions are there in the, my lord, the appropriate rules. And my lord, the inquiry is required to be made for the purpose of eligibility, not a roving inquiry. Lordship knows, my lord, that the judgment has been passed by the Honorable Justice Chittaranjan Das and his companion justice, my lord, as their lordship, then wire. So, however, Abdul Rauf is also seriously interested in getting Emir license in place of late Bilayat Ali, father of the Abdul Rauf. His claim may be taken into consideration in second preference. Who are they, my lord, to make all this observation? Our humble submission from the very beginning, my lord, the authority, my lord, maintaining their nexus with this Abdul Rauf, as a result of which my mother, during her lifetime, my lord, cannot get this particular business. After all, when finally, my lord, after the judgment passed by the Honorable Justice Talukdar and my lord, Honorable Justice Ananda Kumar Mukherjee, my lord, judgment dated 2nd August 2020,
there was a specific direction to the appropriate authority to grant, my lord, in the name of my mother. And at the same time, rejected the contention of the Abdul Rauf, and mat number 289 of 2018 filed by Abdul Rauf is dismissed. Lordship will find from the page 69. What my learned friend is trying to say, my lord, the authority has taken a decision. The decision of the authority is subject to the judicial review of this honorable court in high prerogative writ jurisdiction. They have taken a side from the very beginning and standing on the way, my lord. That being the situation. This is one aspect, my lord. The other aspect is, my lord, lordship kindly come to page 76. Page 76, once again, my lord, I am showing, my lord, the Abdur Ahab from the very beginning, since 2013 onwards, my lord, assisting his father. So, my lord, the question of eligibility, my lord, I think, my lord, I am eligible. I have the experience. Then, my lord, lordship kindly come to, my lord, report. There was a direction from Honorable Justice Vivek Chaudhary to the authority, my lord, to file a report, page 275. Page 275 in the report, page 245, my lord. Page 245 is the report. In the report, my lord, there is a specific direction how inquiry will be made. Without complying that direction, my lord, the provisions are there, rules are there, subordinate legislation are there.
Yes.
They did not take into consideration so far that their own subordinate legislation is concerned. They have done this particular, my lord, the report in terms of their, my lord, objective, subjective satisfaction. And here also in page 247, paragraph C, last 4-5 line, the objection of the Abdul Rauf was not considered as the widow is not required to furnish no objection certificate. Mala, they come to the realization after a decade. This is their regulation, they should understand it. As to why, my lord, the direction is High Court is required, my lord, for the purpose of ascertaining, for the purpose of realization that in case of a spouse, no objection is needed. Had it been within their four corner of the knowledge, then my mother would have got the particular business. And after the death of mother, I am an eligible candidate, so far that particular business is concerned. However, it was noted that in case of Minubewa failed to get approval for the license, the second preference would be given to Abdul Rauf. For the very beginning, I don't know, my lord, as to why they are uttering the name of Abdul Rauf in such a fashion, which is to some extent subject to correction, is a naked one. Cannot be done in this fashion. Their inclination toward Abdul Rauf is on the face of record. Though he is neither eligible nor anything. Then, my lord, I am coming on a 2 point. My lord, I shall not take much more time, my lord. Page 275 of that particular writ application. Then, my lord, when the matter was pending before this honorable court, the previous matter, that number is, my lord, 4740 of 2023. My lord, in this case, after the death of my mother, I have applied. And, my lord, the authority, my lord, maintained studied silence, sitting tight.
Yes.
As a result of which, I moved before this honorable court. The person who is claiming himself to be the eligible and vigilant, he was in the dormant, he was dormant, he was on deep slumber, he did not approach this honorable court at that point of time. This 4740 of 2023, Abdul Rauf did not file any writ application. I don't know whether he had filed any application for, my lord, the particular business or not, but no writ application has been filed. I have filed my writ application. They remain present in that writ application. And, my lord, after the order passed by this honorable court directing the authority to look into the issue and pass a decision order. That is page 275 onwards. So, my lord, one question lordship was kind enough to raise me, to put me. Father died, mother eligible. Mother was not given this particular license. How you were eligible? My eligibility, I am vigilant. I am pursuing it. And this honorable court directed the appropriate authority to look into the issue. They have passed the order. They did not take this particular plea. You cannot make all such prayer. Since your father was our license holder, after the death, your mother was entitled to get the business because of Abdul Rauf, and the department nexus, it was not allotted to her prior to her during his lifetime. You are not in a position to ask for compassionate appointment. They have accepted I am entitled. They have called me, my lord, to be in the meeting. But in the meeting, I could not reach there. WhatsApp call and, my lord, the online, my lord, all these things. I am not in a position to do all these things. I pray for time. They have refused, rejected, and opened this particular category in open category. So that question which was cropped up in the mind of this honorable court, most humbly, my lord, and respectfully, in all humiliation, my lord, I am submitting, in all humility I am submitting, my lord. That is not, my lord, a question is a tenable question because the authority itself considered myself as a, my lord, the compassionate appointment candidate. That being the situation, this particular order was passed by the authority and rejecting our contention and this particular, my lord, this open category, my lord, they have converted into open category. I have challenged it. My second writ application number is 30876/2024.
Yes.
Now, my lord, after this particular writ application, suddenly, my lord, Abdul Rauf, my lord, he is once again in the scene. Because at a point of time, I got the interim order and my lord Abdul Rauf come into the scene. He said, no, I am entitled and there is an order, everywhere it is recorded. And the thing is this, that the next preference is to be given, if given to the Abdul Rauf. So, my lord, kindly consider, my lord, I just only one, I am showing, my lord, only one, their affidavit, my lord. Lordship will find, my lord, from their affidavit, kindly come to page 18 of their writ application. Just see, my lord.
Yes.
Abdul Rauf, son of late Vilayat Ali, aged about 59 years, myself is 47 years. By faith Hindu, by occupation labor. But I am not asking for jingling money in the pocket. But he is claiming himself to be the labor. I have filed one supplementary affidavit showing that he is not dependent in any manner whatsoever. So what is required to be ascertained, whether he is dependent, whether he is eligible. My eligibility I have shown since 2013. Before that also I am doing business with my father. Father allotted me, father entrusted me, father authorized me to do all this business. And my lord, here in the affidavit, they have categorically stated, they are the labor, he is labor, and my lord, my senior repeatedly said, I have that financial capacity, I can do this business. This is called eligibility. Our humble submission, this cannot be treated as an eligibility. Eligibility means, my lord, the experience, who knows the business, I know the business. And the other question is whether I am dependent. I am claiming myself to be the dependent. Lordship will find number of papers and documents are there where I am doing business with my father. Since the very beginning, I do not know anything. I do not know any work. I am not in a position to cultivate in the land, in the scorching sun. I know this particular business. Thereafter, I am dependent, out and out dependent since very beginning of my father days. Now, my lord, the question is whether Abdul Rauf is eligible or not. So, for financial capacity is concerned, they themselves, my lord, declared themselves labor. My lord, our humble submission, Abdul Rauf is dependent one. The sisters are with me. They have consented. Abdul Rauf stands on the way. Lordship knows, my lord, in Hindu law, there is a provision. If someone kills his father, whether he is entitled to get the property of the father. My lord, subject to correction, my lord, my answer is no. Here, this gentleman standing on the way did never permit my mother to be the owner of this business. Now he is trying to stand on the way as a stumbling block so that his brother who gets the support of the sister may not get this particular business. Then, my lord, this is, my lord, almost all submission. And previously, my lord, I have made my submission. That particular judgment I have referred. Justice Chittaranjan Das and Parthasarathi Sen, my lord, past number of judgment. What is called, my lord, the inquiry. It is not roving inquiry. I have relied upon. My lord, Shalini Shetty judgment I have referred. Just one line I am reading. When, my lord, the authority and a private individual is acting in collusion with a statutory authority. Page, paragraph 59, 63, 65. So here is an instant case, my lord. They are very beginning, my lord. And, my lord, this business, they did not permit to operate, as a result of which there are other beneficiaries. And whether that beneficiary, my lord, sponsor myself, this Abdul Rauf, I don't know, my lord. Decades, my lord, much water drained through the river of Ganges, through the river of Padma, but I did not get my mother did not get it. Now, once again, they are standing on the way as a stumbling block, my lord, so that this honorable court may not consider my legitimate claim, and my claim is supported by the sister, and they are, my lord, consented. That being the situation.
This is not the point of law. You have to argue on the reply on point of law. This fact.
But I am completed.
Okay, you have completed.
My lord, the point of law is, my lord, the eligibility and dependency factor. And eligibility and dependency factor, there was an inquiry. Inquiry says Abdul Rauf should be given second preference. That report cannot be accepted in any manner whatsoever, because Lordship knows, my lord, the rules is very clear. My lord, rules is very clear. I am showing, my lord. Here the subdivisional collector, food and supply shall arrange for an inquiry. There was a direction, they did not, they are reluctant to do that. There was a direction from the Honorable Court to verify the eligibility of the applicant. And to submit the report with his opinion to the district collector. So, my lord, eligibility question, dependency factor, consent of all persons are not to be taken. That is the mandate of the division bench judgment. And eligibility, myself is eligible, I am doing this business and very big. So, they did not, my lord, they did not confine themselves within the four corners of their subordinate legislation. My humble submission before this honorable court is this. The report is lying in the record. I have filed my supplementary affidavit. And my lord, the judgment I have filed, this is my humble submission before the very good. But possibly I have completed within, my lord, 7-8 minutes.
Okay, who is for the added respondents like that? Yes. What is your submission? Now, whether you have heard the submission of the senior counsels on behalf of Abdul Rauf that sisters are not eligible persons or they are not required to be heard by the subdivisional controller? Huh? Yes, sisters are married sisters. See the control order. It has been argued by the senior counsel on behalf of Abdul Rauf that married sisters are not a family members on the definition of family. Yes, you place this. Okay. You place this.
Nothing remains.
Okay, argument close.
Close.
I have taken note of all your arguments and point of law, everything.
Only one sentence may I add, my lord?
Yes.
Only one sentence. Only one sentence.
No objection, it may kindly be recorded.
No. Okay, question of
I'm
law.
not raising objection.
Question of law. 25th of August 2014, on the basis of order of the Honorable High Court, inquiry was held by the Subdivisional Controller of Food and Supplies. He submitted a report. That report was accepted by the division bench. Division bench said, directing the authority concerned to act on the basis of the said report. Only I am reading. The respondent number 7 and 8 are directed to give effect to the order dated 25th of August 2014. This is me.
I know that.
No.
Please take down. Argument on behalf of the parties concluded, made CAB. তিনটে ম্যাটারই পাঠিয়ে দেবেন হ্যাঁ Yes.
Before going to the paper book, just only nutshell I'm giving the gist so that your lot can take note of the relevant points and the factual matrix from the paper book. My lord, the order of the appellate authority was subject matter of challenge before lordship. In respect of the a prima facie tried to be make out by the appellant before lordship in the second appeal. Now, my lord, we oppose strongly with regard to the what are the infirmity in the order of the appeal court, which is the subject matter of challenge in the second appeal.
Yes.
Now, normally, my lord, unless there is a substantial question of law which has not been ascertained or determined by the court below, in that event, my lord, stating my lord, jurisdictions in second appeal, section 100 of the Code of Civil Procedure, my lord, High Court can intervene with regard to the matter. My lord, just I am drawing lordship attention to this fact. Initially, what are the order passed by the court below, and what are the order passed by the appeal court? Then, my lord, come to the my lord, relevant documents in respect of the LCR and others relied, which has been submitted by the respective party before. Now, if your lordship takes trouble to the impugn order which has been passed by the court. The suit was filed by the appellant before the court below as a plaintiff.
Yes.
My lord, what is the suit for? What is the suit for? If your lordship takes trouble to the suit for declaration of title, confirmation of possession, and recovery of cause possession. My lord, it appears from the page 2 of the my lord, paper, volume 1.
Yes.
Now, my lord, this is the suit, and what is the relief short for? If your lordship takes trouble to the there. And in the suit,
yes, proceed.
In the suit, the defendant contested the suit by filing WA, issue were framed, evidence was made, and thereafter a prolonged judgment was passed by the court. Now, if your lordship takes trouble to the relevant portion of the judgment, which is very pertinent to be considered by a law. Should I read?
Yes.
The case of the plaintiff in brief that they disputed property in respect of 16 decimal of legible. I am referring the page 2 of the paper book 1. Plot number 477 of PF Khutian number 148, LR Khutian number 187 of Moja, Kushan. The disputed property originally belongs to Kedarnath Mondol, and while he was exercising right title interest and possession over the said property, sold 1.61, including disputed fixed decimal by registered deed to the plaintiff, and delivered possession thereof plaintiff has been possessing the same since purchase and subsequently raised a residential construction in the one portion of the same property. The defendant is a familiar to the plaintiff and is a co-villager. Let's approach him for granting license for the temporary period in respect of the residential room as when residential room as mentioned in the schedule of the plaintiff as defendant was undergoing an essential inconvenience. Well, plaintiff has kind-hearted granted him license in the month of Boishak, 1380 PS in respect of a residential room temporary, and since the eligible granting license, defendant has been possessing the said room in or schedule mentioned property on the condition to vacate the same within a few days for construction temporary residence in separate thing. Malad, plaintiff is the owner in respect of the suit property and defendant is seeking a license for accommodations for a certain period for construction a room in respect of the property, and petitioner granted him in respect of the same.
No, I know the entire fact. The entire area is the 60 decimal. Cost schedule is the 52 decimal, and cost schedule is the 8 decimal.
Some confusion.
Some confusion is there, such as the 8 decimal is not there. So this is the not disputed. Dispute is that whether the license was granted or not, whether it was revoked or not.
Correct.
That is the only issue here. Okay.
So for this area, so for the question which is fallen from your lordship, I try to assess your lordship. But that normally there is no execution of license in favor of the defendant was given by the plaintiff anytime. Anytime. It is admitted because it's oral.
Yes, oral license.
Oral. Number one. Number two, he assured, subject to kind sanction, in understanding, I believe after making my residential house thereon, I can shift it or there. But that has not been done, which compelling the petitioners, opposite party hearing, to file an application with the court. Now, so for the ownership is concerned, in respect of the plaintiff party is concerned,
not disputed.
Not. And there is no question raised anywhere by filing WS with regard to the right.
In the WS, they have pleaded the adverse position.
Now, question comes. So, for the nomenclature of the adverse position is concerned, it's different. So, for the what we are trying that you are occupying a premises in oral license, and there is no existence of license, and you are, according to the petitioner, to vacate the premises, and as you fail to comply the request of the plaintiff, he compelled to file this application with you. Now, what is the observation of the court? If your lordship takes trouble to the order. My lord, if your lordship, just relevant question I am drawing lordship, because your lordship have page 10.
Yes.
Only 2 lines I am reading. From top, there is no dispute that the plaintiff is the owner of the disputed property of the party. It is admitted, your lordship. From the exhibit 2, I need not to trouble your lordship much. Then your lordship kindly come to the page 12.
Yes.
Followed from 8 line, I am reading on page 12. The RS record, Khotia number 425, exhibit B, goes to show that the Bipin Haldar was in position in respect of 4 Anna share of the disputed property as a license. Followed CS corroborating the RS, followed by the LR. All through the name of the petitioner here, along with the deeds. So for the ownership part is concerned, there is established. So for the 5/6 decimal land is concerned, my lord, I need not to make any trouble because, my lord, that was not with any question from the side of the defendant. Now, my lord, here, page 13. Thereafter, my lord, suddenly the court below, the trial court, observed here plaintiff could not establish the relationship of alleged license and licenses in between the parties. As such, the application which has been filed by the plaintiff before the court below, so I am asking for right title interest with regard to my property, supported by sale deed, reader's notice, followed by RSCS and other relevant documents supported before the court. But court held, I have no appeal. Ultimately, my lord, I prepared an appeal before the appeal court.
Yes.
Against the judgment and decree passed by the lower court.
Suit was dismissed on contest.
Now, my lord, the appeal court elaborately record the submissions of the respective parties and the evidence which has been enunciated by the my lord, evidence, and also taking note of the exhibits. Thereafter, my lord, I am relying lordships, my lord, the relevant provisions in the judgment, page 20 onwards.
Page 20.
20. This appeal against the dismissal of the suit filed by the plaintiff, appellant for evictions, defendant respondent as a license in cost schedule, dwelling house for 8 decimal, and for the declaration of the cost schedule property for 60 decimal, and for permanent injunction against the defendant respondent. The plaintiff appellant has adduced relevant documentary evidence, the registered Kovala of 1943 Exhibit 2, to prove the title in cost schedule property. The dispute is that the defendant respondent has acquired title in cost schedule property for 60 decimal by adverse possession since his father Bipin Haldar since 1365 PS. Admittedly, Bipin Haldar, father defendant respondent, died in 25th April 1984. As the defendant respondent has claimed title in the suit cost schedule property by way of adverse position, I am stressing your lordship, my lord, this mark, because your lordship, my lord, according to the settled principle of title of the plaintiff or appellant in the suit, property is obviously admitted by the defendant and respondent. Now it is to be considered whether defendant respondent has established his title in the suit property by adverse position. Whereas learned court below has held, considering evidence adduced by the defendant respondent, that the defendant respondent has failed to establish his title in cost schedule property. My lord, in this regard, the learned court below has observed that there is a categorical pleading in the written statement that the Bipin Haldar, father of the defendant, forcibly entered into the suit property since 1365 PS. And all the sons and daughters were born at the suit property, and his parents died there, and marriage ceremony and his son and daughters were performed at the suit theatre. And to prove the same, is the defendant himself as a deposed as DW1, DW2, DW34, where DW1 has deposed in chief that he entered the suit property in 1365 PS and crossed as 1362 PS, and Ajit Khala and Bhavesh Das were witnessed as the forceful possessions, where defendant witness 2 and defendant witness 3 have deposed that they were not present at the time of taking forceful possession. Your lordship got the point. Now also, defense witness 1 has deposed that the time of the age 15 and 16 years, and he has document to show that he was born at the suit land, but there is no convincing evidence besides the verbal testimony of the DW1 that Bipin Haldar, after forcible possessions, constructed retail and take form and planted different kinds of trees, but DW2 has deposed that he cannot say who constructed the retail. He has also deposed in his cross that he did not see Bipin, father of the defendant. The learned court below has also observed rightly, relying upon the exhibit P, RSRI. Your Lordship, I'm submitting before Lordship.
Yes, proceed. I know the RSRO.
Showing possession of the people in respect of the 4 anna share in the suit property, that the presumption of possession can be drawn, but that entry court cannot hold, Bipin hold was Haldar was in adverse possession of the suit property. Rather, exhibit B clearly shows permissive possession of Bipin in respect of the 4 anna share constituted property. And in respect of that party is also no cross-examination also filed before the court. Now, my lord, if your lordship takes trouble to the relevant portion, my lord, kindly come to the, without wasting your lordship valuable time, one page I'm reading, lordship, so that your lordship.
Yes.
So the defendant relied exhibit B and ROR in the name of Bipin Haldar, and the same has not been challenged by the other side. My lord, I need not to trouble your lordship. LR record or RS record, it doesn't confer the right title in respect of the property unless supported by any deeds. Here, in the all three of the proceedings, they are only relied in respect of the adverse position.
RSROR Onumoti Dom.
Onumoti Dom. It doesn't confer any right.
I know that. Yes.
Now, my lord, considering the above observations, learned court below, relying upon the evidence adduced by the defendant regarding the adverse position, I find that the learned court below has rightly decided that the defendant has failed to prove his title by way of adverse position. I also find in the appeal there is no cross appeal preferred by the defendant challenging the said decisions of the court below against him. Well, so far the right title party is concerned, that has also not been challenged by the defendant in a separate cross appeal in respect of the right title interest of the plaintiff, which has been shot for before the court. Now, my lord, further I find LR record of right exhibit that the entries co-schedule land has been recorded in the name of the defendant showing possession since 13 BA, and from exhibit C, Onumati the whole matter. I need not to trouble you. The order of the proceeding preferred by the plaintiff or appellant challenging that the said recording, it appears that the petition was disallowed and held by the defendant was possessing an entire suit land for more than 35 years and case was disposed of. In respect to the LR entry is concerned,
yes.
I need not to trouble about it. In this regard, I find defendant is the son of Bipin. Well, Bipin is already expired in the year of 1984. Was admittedly died 84 and as per exhibit 3, RS Arua, Bipin was recorded as a permissive possession in respect of 4 anna share in the suit property, and father of the defendant being died in the year of 1984. This defendant cannot anyway possess the entire co-scheduled property since 1965 or more than 35 years. Further, settlement defendant cannot decide title of the party and need not to trouble the lordship. Accordingly, by the said decisions of the proceeding exhibit C2, the learned settlement department cannot decide title dependent on any other word. Defendant cannot acquire title in the said property in any manner. I need not to repeat because the lordship has already been. In spite of all these aspects, the learned court will have hesitated to declare the title of the plaintiff in co-scheduled property. Rather, the learned court will have held that observation that the plaintiff has not acquired title of the disputed plot by rested Kovala. So, there is no denial from the side of the defendant. I am stressing here, lordship, on the ground that there is no evidence that the dispute plot 477 under 40 and 148 by 1 is same and identical with one of the three plots 461, 462, 466 and other three being no demarcation in core and core. The title, the settled principle is the admitted fact need not to be proved according to the settled position of the law, because it is the admitted fact, so it is not required to be. The suit property is purchased by the plaintiff. The disputed is the defendant is the acquired title by adverse position since his father. In the same judgment of the learned court below has decided the same breath that the plaintiff has no title by the purchase and the defendant has also not acquired title by the adverse position. This is completely wrong. In this case, there is no question of demarcation of co and co-schedule, and there is no question of identification of the suit clause because there is no case of encroachment, and also from averment that the plaintiff ROR is clear that RS Khotian 141 is LR Khotian number 1087, and from exhibit filed by the appellant before the appellate court, it appears that the suit plot code 77 was recorded in the name of Bipin Haldar, was permissive possession in respect of the 4 anna share of fixed decimal. And it is also not disputed that said plot is mentioned in the imprint purchase deed exhibit 2. So therefore, admittedly, the defendant and respondent is in possession in co-schedule property. The LR ROR shows that the defendant is in possession of the entire suit property. But possession does not confer any title, and it has already been decided that the defendant has not acquired any title and suit property by an adverse position. Then how the possession of the defendant in co-schedule property is a legal right? In spite of all this, court below has dismissed the prayer of the eviction of the defendant as licensed on the ground that plaintiff has not come before the court with a clean hand. He has suppressed the permissive possessions of Bipin, father of the defendant, in respect of 4 anna in co-schedule, and has failed to prove induction of a defendant as a license where PW prosecution witness number 2, the corroborative witness, has to stop the induction of the defendant as license, has not uttered in the name of the defendant in the cross-examination, who has deposed Bipin Haldar as a license under the plaintiff. The settled position of the is that the civil cases principle of preponderance of the probability as applicable. Regarding burden of proof in the matter of the license, learned lawyers for the respondent has referred a reported decision 101 CWN 159, wherein the decision of Supreme Court AI 1975 Supreme Court 157 relating to the proof of preponderance of probability. In the case, it is clear the evidence of Bipin Haldar, father of the defendant, was licensed in respect of 15 December and he died on 15 April 1984. So, there is not the pleading of the plaintiff. The plaintiff case is defendant was licensed under the plaintiff in respect of 8 decimal only. The fact of the Bipin was automatically, while evidence was folded before the court. This is, to my mind, should not be considered as a suppression of fact. While reviewing the plaintiff, written statement is filed in defense case. In this way, the entire case of both the side is coming before the court and to decide accordingly. PW1, the prosecution witness 1, the plaintiff was obviously discharged his honor by adducing oral evidence as well as induction of a defendant as a license. And then all these facts and documents as to license of the father of the possession, defendant has become before the learned court below, and by date of Bipin Haldar, the earlier permissive possession, in other words, license automatically terminated. Regarding omissions, to frame issue of the learned lawyer for the respondent defendant has reported decisions in 1994 to 31, where it has been held that non-framing of issue will not be fatal when both parties go to the trial knowing each other. He has also referred another reported decision there in 1971, Commission 191, wherein it has been held that court can frame an additional issue and allow the parties to lead evidence thereon, even after commencement of the argument. In this case, considering the above discussion, I find there is no question of framing additional issue and to give opportunity of addition further evidence. Also, that the vital issues were not framed but discussed in the judgment, and both parties adduced evidence according to their pleading, and for the non-framing of issues will not fatal in the case. For the possessions of the defendant the learned lawyer for the respondent has advanced argument referring the reported decision of 1979 CWN 227 that the defendant cannot be evicted. In this reported decision, there was license from the government to cut, fill, and exact streams and timer from certain areas, and license liable to be terminated on default of the payment of royalty and license abandoned work, government revoked license and took possessions where question was raised whether the grantor entered into the possession without recourse to the court. An observation in AIR 1959 Allahabad, I referred in the reported decision which is under law, respect possessions even if there is no title to support it. It will not permitted any possessions to take the law in its own hands and to dispossess a person in actual possession without having recourse to a court. In this case, there is no question to take in possession by the appellant without recourse of the law. Here, the appellant plaintiff has filed suit for eviction a dependent or respondent license. Thus, reported decision is not applicable in respect of eviction. On the other hand, the learned lawyer plaintiff appellant has reported decision 1967 Gujarat 1, wherein it has been held that the plaintiff failed to establish his case, he can still get degree on his basis of the case without the defendant, but not plaintiff claim on his basis of the part filing. Considering the entire discussed above, I am viewed the preponderance of the possibility will go in favor of the plaintiff appellant, and I find the defendant respondent is nothing but a license under the plaintiff which has been duly terminated by the service of notice exhibit 1, and such defendant is liable to be evicted or scheduled property. I find the learned court below has erred in dismissing the suit. Accordingly, the plaintiff appellant will get victory in the suit as prayed for, and the such appeal is allowed. And of the appeal, subpoena stamped in the appeal and the same is allowed on contest, judgment and decree passed by the court below. The plaintiff appellant was the next
Not decree.
Now, the decree was passed, followed by the judgment. It's page 30. I need not to go through the followed again and again. Only what are the infirmity in the order passed by the appellate authority, which has been shot for before lordship in its second appeal. Well, so far the initial suit for right title interest of the petition. So for the defense of the defendant appellant hearing, they are in adverse position. But so far the LR record is concerned from the RS or the LR, which appears that they are pharmacy positions of the Bipin Haldar, father of the appellant, and father of the appellant was expired on 25/4/1984. And after expiry of the father, the pharmacy positions which automatically terminate by operation of law. So far the status is concerned, they are illegal occupier in respect of the property. Against them, a suit for eviction is the appropriate proceedings which has been proceed before the court.
So what are the substance and question of law?
Now, my lord, I could have been understood that my title was raise the question before the court. That question was not been coming through from their side, or they have not been filed any cross appeal against my right title interest of the subject suit since the inception of the civil suit initiated before the court below, even appeal and thereafter. So, right title interest of the plaintiff or the opposite party, he was no question. On the contrary, they are harping on the issue with regard to the adverse position. So for the question, I could have been understood, that the court below failed to consider this document which has been placed before the court, that has not been considered. I could have been understood that the court below, without applying their judicious mind, despite no opportunity has been given, I could have been understood that they have been violated the principle of natural justice. That's not happened. But I could have been understood that the particular document, which is a very vital document, which has been placed before the court, that has not been by Firisti, that has not been taken into account.
Why you are arguing on this point? The point has already been framed by the learned by this court.
Only I try to submit before lordship what are the grounds in the second appeal normally.
No, not required to be argued on that point. You have taken the page 45 of the paper book, the substantial question of law.
Lordship.
which was framed by this court, by the division bench of this court regarding hearing of this appeal, second appeal, not other points.
Lordship. Well, so for the question number 1 is concerned, because my lord, before admitting the my lord, second appeal, normally court, my lord, some question of law has been framed, and thereafter my lord, admitting the appeal for proper adjudication of the matter if the appeal has filed with delay or not delay. If with delay, then condonation of delay has to be considered, thereafter admitting the appeal. Now, my lord, take trouble to the first ground which has been placed before. My lord, before analyzing the ground number 1, my lord, if your lordship hard in law, the main one sentence has been used in respect to the ground number. My lord, I am putting this question to myself. So, for the judgment of the trial court and the judgment of the appeal court and the WS which has been presented before the court and the evidence which has been placed before the court.
Yes.
In respect of the documentary evidence, had there been any omission on the part of the appellate court, I could have been understood that this point has not been considered while deciding the issue by the appellate court and set aside the order of the trial court. So, my lord, mere recording or mere making a submissions are in law without disclosing the reason or furnishing the justifications for making this amendment before the court, well, I could have been understood to myself that this is a hyper-technical or mechanical word which has been issued. Because in the four corner of the trial court's order as the appellate order or even the appeal, my learned client failed to justify what the appellate court are in law in respect of deciding the issue. So, in absence of the same, this point your lordship can consider.
So there are no error in the law by the learned first appellate court in deciding the issues. And this matter regarding error in law was not raised by the appellant before this court.
Anywhere.
Anywhere?
Anywhere. No point has been taken.
No point has been taken. This is your submission.
Lordship, since my lord, the court below.
Yes.
Even my lord, before the appellate.
Next.
Now, my lord, so far the question number 1 is concerned. Now, question number 2.
Yes. Yes.
My lord, I am ready. Plaintiff, in the fact and circumstances of the case, being able to prove the case brought by him and entitled to get a degree passed for on the basis of the evidence adduced by him as to whether the learned judge in appeal court are in law. In setting aside the judgment of trial court dismissing the suit and granting a degree on favor of the defendant to prove his defense. My lord, it relates to some extent with regard to the Ardin law. If
now, only emphasis in the point number 2 is that decreed in favor of plaintiff granting decree on failure of the defendants to prove his defense, whether it is are in law or not.
My humble submission before lordship, my lord, that the
is there any observation in the appellate court that as the defendant has failed to establish his defense, so the plaintiff is entitled to get the decree?
No.
Is such observation is there?
No. If your lordship takes trouble to begin, if your lordship, so for the ground number 2 is concerned, if your lordship takes trouble to I'm ready. So for the relevant question is concerned, Your Lordship mark so that I can answer.
Yes.
Your Lordship mark it so that I answer. Now, so for the question number 3.
Yes.
The learned court in the court below rightly reverse the judgment of the trial court. Learned judge in the court below rightly reverse the judgment of the trial court dismissing the suit, holding the plaintiff has not been able to prove his case. Your Lordship take trouble to the language. Whether the learned judge in court below.
Yes, that is the first court.
First court, but that means Malord the Munsif. Rightly reverse the judgment of the trial court, trial judge, dismissing the suit.
Framed otherwise, that is the wording is otherwise.
So I need not to trouble Lordship.
Yes, proceed.
This is nothing to be a mechanical approach before Lordship. I need not to make any comments. Your Lordship mark it. Now, can we come to the round number 4?
Yes.
Whether the plaintiff has been able to refute the entry made in the record of rights, which stand in the name of defendant. Should I make any comment? Because the RS record and LR record in respect of 8 ANA shares of the BIPIN.
4 ANA shares, not 8.
Stand corrected. In respect of the BIPIN. BIPIN expired on 25th April 1984, where it has been referred as a permissive Onumuti Dokos. It stands.
Whether there is any prayer from the plaintiff that the entry made in record of right is erroneous?
Erroneous, that was disallowed because RS.
No. Whether in the suit there is any prayer like that?
It has been observed by the court. Both the
No, not observed. Whether there is any prayer in the suit regarding erroneous record of right? No. No, there is no such prayer.
Because I am asking.
But why this was framed?
I don't know why it has been.
Plaintiff never prayed for rebuttal of record of entry in the record of right.
It is not, I need not to make any comments to that aspect.
Very good. Next.
5. Whether the learned judge in the court below justify in reversing the judgment and degree of the trial court when the relation of the parties is claimed as a license and licensee if not proved by the plaintiff.
So relationship between licensor and licensee, whether proved or not correctly, and whether it was determined by the appellate court. This is the point here.
So for the trial court is concerned.
Trial court has observed that the relationship between licensor and licensee has not been proved by the plaintiff, whether that has been considered by the appellate court. This is the only question here.
In respect of that aspect, the DW2 has made depositions to the court that the Bipin Haldar was licensor in respect of oral. There is no documentary evidence. And in respect of his depositions and the cross-examination is in the report. So for the observations and the citations and the submissions which has been enunciated in the deposition which has been part of the NCR, the appeal court comes to a finding.
Yes.
And pass an order that he is a licensor. And on the basis of the relevant documents and the observations and the depositions made by the respective witnesses, pass an order. Rightly in favor of the appellant.
Very good. That's all for today. How many time you will require?
My lord. Half an hour next day. If your lordship tomorrow, my lord, fix any date, my lord. Tomorrow I shall conclude the and your lordship can pass this. If my lord diary permits, lordship, I'm ready with the matter.
Diary is congested only for 3 days.
My lord, and thanks to your lordship, my lord, that your lordship, even my lord, busy schedule, your lordship, my lord, deal with the matter.
24, 25 না আজকে কত তারিখ 20 কালকে 21 21 কি আছে সেকেন্ড হাফে সাড়ে দশটায় কি আছে? হ্যাঁ? ও, Honored Advocate General is there, 10:30. Very good. Come on at 4 tomorrow, 4 p.m.
My lord, rising your lordship, my lord, I beg to mention item.
Why you are like dying like that? I shall not hear anyone. Let me finish this matter. I have not passed any order.
Sorry, sir. Excuse me.
All matter will appear after vacation.
Sorry, my lord.
No issue.
My lord, can
Yes, no.
interim
just
order-
wait. বড় কি আছে? Three matters. তাহলে তুমি চারটেতে রাখো। চারটে। It will fixed at 4 p.m. 4 p.m.
My lord, can this can application be heard on tomorrow? Or,
Can application in respect of what?
Interim order.
Interim order which has already been expired long ago.
Whatever may be expired, let it be disposed of along with the writ petition,
Main
along with the main appeal. Main appeal, interim order, which was extended earlier, it would be continued till the disposal. Okay.
My lord, not disposal, my lord.
Why not disposal?
I'm-
I will dispose of this matter. If you ready, I can tomorrow dispose of this matter.
I'm ready with it.
Tomorrow I can dispose of this matter. I can finish the argument. If both of you are ready, I can finish that tomorrow. Come on,
I'm
tomorrow I will
also
pass the
ready.
order. I will pass the similar order. I have passed the interim order so that the matter may be disposed of.
So kind of flush. So kind of flush.
Please take down.
My lord, just one minute.
Please take
Can
down.
it-
Let the matter appear in the list.
Can it be possible to 345? Because after completing my submission.
No, I have 3 fixed matter, long matters. That's why I fixed the matter at 4. Let the matter appear in the list on 4 p.m. tomorrow.
Lordship, before rising, my lord, may I pray for an indulgence, my lord?
For what?
With regard to 3:30.
In these hours?
No, with regard to 3:30 matter. my
Yes,
lord.
today is a fixed 3:30 matters.
Lordship,
Could not take up these matters today.
No, your lordship, that is not an issue. Lordship, can it be fixed at 11:30 tomorrow?
No, I have already fixed 10:30 matters, 12:30 matters, 3 matters. Thereafter, 2 matters at 2 p.m.
And then
You have the opportunity
Lordship,
to do these matters
because
on 22nd at second half if there is no 3:30.
no, Lordship, tomorrow because 3:30.
Tomorrow is not possible. Tomorrow I have already busy. I have already fixed several matters.
Lordship, today 3:30 was fixed, my lord.
I understand. I could not take up this matter.
No, that is not the issue, my lord. Let it be continued tomorrow because we are in a tentative position. Because if it is 3:30, then it might not be taken up. That is the whole issue, and it is very urgent because there is a.
I know it is urgent, and that's why I fixed the matter to today.
Lordship, there
I
is
could
a
not take up this matter due to paucity of time of other matters.
that might be.
No, I am saying that the 22 is the day when I will take up these matters on second half. 22 I fix some matters for hearing learned advocate general day after tomorrow. So that is 20. No, tomorrow no chance. Already fixed matters are there.
And tomorrow 3:30 will not be taken up. If your lordship grants that liberty.
Tomorrow I have 3 matters 2 p.m. 2 p.m. 3 matters. I do not know whether I could fix the complete those matters before these matters.
Lordship, then in that event, can it be fixed on 22nd?
22nd at 3:30.
Not at 3:30, a bit earlier, my lord. It becomes very tentative here.
No, 3:30. I think 22. It will be no 3:30. 23rd maybe 3:30.
No, Lordship, it becomes very tentative. Lordship will kindly consider, my lord, there is a vacancy notification that is.
Very well. I am fixing the matter at 2 p.m. If the other matters concluded, your matter will be taken up thereafter.
Let it be taken up. Otherwise, we will be in the petitioner will be near.
I understand all the matters are very urgent matters. So that's why I'm fixing the matters, accommodating you.
Lordship will kindly consider.
3 matters are there at 2 p.m. 3 matters, all the matters are vices of act has been challenged. That is the issue. Our stuff is not possible. You know, there are mentioned matters are there. Mounting. এটা ফিক্স করো যেটা 3:30 তে ফিক্স ছিল এটা 2 p.m. ফিক্স করো নো এটা করো 3 p.m. ফিক্স করো 3 p.m.
3 p.m.
3 p.m.
Tomorrow, you're not.
No, 22nd.
My lord, under circumstances, I beg to mention before your lordship, item number 61, we filed an application for appropriate order. In my
Sir, you
application,
have filed the application,
Sir,
I have heard twice.
yes, I stated
Then-
that, but the writ petitioner obtained order by practicing fraud upon the court, my lord. I shall satisfy your lordship, my lord. My lord,
You have
kindly take.
already know the matter, that this is pending.
My lord,
Division
no.
bench is pending, the order
No,
is there.
that division bench order is in my favor, my lord. My lord, I shall satisfy your lordship. I'll take it tomorrow, my lord. Any
No.
moment, my lord.
What
Item
kind
number
of-
61, my lord. Under heading application. Today is appearing under heading application, my lord. No ration cards delinked from the petitioners.
It will appear tomorrow. It will appear tomorrow. No issue, it will appear tomorrow.
Mine is also
Application.
That is also an application, 62.
May pay at the top, my lord.
We can maintain in the list. We can maintain the list as it is appearing, okay. If it is possible, I can take up these matters. So not necessary to
I'm extremely.
pass any order.
My lord, I was appearing in item number 6 today regarding the married. I'm okay.
Okay, thank you.